అవునే ఆర్డర్స్ కట్టుకుంటారు. That's my apologies, Lord. Can I make a mention in respect of a dispose of matter in different combination, Lord?
Oh my God.
Reason is only this, Lord. Lord, this is that KADB land acquisition matter.
Yes.
Lord had granted us an interim order, Lord, for a period of 4 weeks.
Hmm.
But the order was passed on 21st of Lord, February. The order was Lord, uploaded on 5/3. Lord, Supreme Court was closed the entire week because Lord, on 20th Lord, is the last
Same
date.
submission.
We'll have to make the
Yes, Lord.
list.
Lord, your lordship would indicate
They had
4
already
weeks from the date of certified copy, that will be the, or matter may be listed on Monday or
It
Tuesday.
has to be listed.
it
For
will
Please.
have to be listed. Lord.
done, it has to be listed.
Yes,
Please.
but
Without
our
which we
difficulty
can't
is not
We
20th.
want only 2 weeks, my lords, 2 weeks.
20th Lord is the last date. Lord, that is the reason I'm making a request before Lords in this bench. I'm sorry, Lord.
Listed. Yes, we list it on Tuesday.
Please,
Very well. Grateful.
Tuesday would be within the time.
Very well. Grateful.
2:30, my lords. 2:30.
Please take a,
Yes,
Please.
it will be informed in advance,
grateful.
whatever the timing.
Please.
My lord.
RFA also, my lord. Urgency is, my lord. Execution gets on. Different from execution proceedings has been started, lord. Possession warrant issue. I have moved before.
This is with earlier one. Oh my God.
I have moved before this.
Is it, where is he? In Kalburgi. Kalburgi, he's gone. See whether when it can be posted. Yes, yes.
Possession warrant has been issued.
My lord.
One more different combination, my lord. Sorry, my
Today appears to be a different combination day.
respect to, month can come out. And your lordship, my lord, dispose of the writ petition with the direction, to the petitioner, that is for me to file my response before the admission overseeing committee.
Hmm.
My lord, there is no, chairman of the admission, overseeing committee, my lord, and they are not accepting my reply. 3 weeks time, my lord, had given expired on last Tuesday and did not accept. And they were telling me to go file it before the fee regulatory, committee, but that is not your lordship's order. Your lordship's specific order was to file it before the admission overseeing committee.
Yes.
My lordships, in
All you're required to do is file it.
Yes.
Therefore, can you not send it by registered post and say that you filed it? Just wondering aloud. Because what else can we cannot ask one committee. Your contention is that one committee does not have jurisdiction. We have left that issue also for consideration of the same committee.
Correct.
Therefore, the further steps.
But the employee of the KEA, is just sitting there just to answer these kind of queries, lord. So there is no.
File it when there is a direction as such, and as such, nothing further unless the committee is there and issues you a notice on the response that you have filed. Nothing further happens. You insist let it be posted when the combination will have to be known. Actually, according to me, I don't think it is required, but it may not be proper for me to say anything in a different combination. List it if that combination is being.
my lordships,
Judicial. Yes.
my lordships, the MFA 69901, the respondents have filed separate appeals before this court, and we are on the we are not served. We are on the caveat, but we are not served with the copy. Kindly it may be posted on 19 my lords.
Something which is not
MFA
there.
6992.
Number 1 and 2. Page
One,
Senior has some inconvenience. 20th melody.
one is a year for substituted service.
Is dispatched.
is listed for.
Thing is, there only one IE for substitute services been uploaded. Please give me the file. You're for the
I am for the
appellant.
appellant, my lord. Senior Inconvenience, and 20th may be fixed for that.
The
Senior.
service is complete to everyone.
Please,
It
please.
is. For hearing, your
Special
Lakshmi
bench, my lord.
kindly
Yes, it has been listed for hearing.
hearing one.
2
I-
acre.
we are
one
ready. So
gutta,
far me is
subject-
concerned,
yes,
I am
yes,
ready.
yes. Swami, I looked up this matter also. We've looked up the matter.
Yes.
But Senior counsel is held up in special bench, my lord, that's why.
I am
Next week,
Hold him.
20th, my lord, your
20th, my lord.
specifically. Lakshmi kindly at 2:30.
no, 2:30, sorry.
Mobilize.
Same,
Please,
please be ready on that day.
please, please.
Yes, at the request of the.
Given date, they are not arguing.
Hmm.
Once again, for the.
Hmm.
Given date ಅಲ್ಲಿ ನೀವು
ನಾನು
argument
ಈ-
ಮಾಡಲ್ಲ. Once
No, no, no.
again ಎಲ್ಲೋ
I am so far me.
ನಾವು ನೀವು argument ಮಾಡಲ್ಲ.
So far me, I am ready, my lord. I will argue. Synopsis is filed
Special
and
bench, my
everything
lord.
is. I am ready to argue today itself.
Listed today for argument only.
After lunch,
Sorry, my lord.
after lunch,
2:30.
after lunch today,
Please, I will try, my lord. She will convey to that.
we'll make an attempt.
Please,
After lunch.
please.
Yes, pass over.
ಇದು ಇಲ್ಲ ಇಲ್ಲ, ಅದುವೇ ಒಂದು just 5 minutes.
Page 2, the number 3.
Serial number 3, my lord. For the state, we post on next 19th or 21st, my lord. I've informed other councillors. Sir.
Spend so much of time. What is this council?
AG is stuck up in a special bench before the 6th, my lord. 19th or 21st, my lord.
Same submission ಮೊನ್ನೆ
ಇಲ್ಲ
ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಅವರೇ ಅಪಿಯರ್ ಆಗಿದೆ ಸರ್ ಬೆಳಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ ಅಡ್ವೊಕೇಟ್ಗೆ
Same day, 2015-16, notice issued after 2 years.
ಈ stuck up in special bench, my lord. Part of matter in quarter number 6. Right.
You're not interested after vacation ಹಾಕಿಬಿಡಿ ಹೋಗ್ಲಿ ಬೇಡ ಅವರಿಗೆ.
Let us, yes.
Yes, yes. You're not
Set up.
interested to argue after vacation ತಗೊಳ್ಳಿ.
Next week, my lord.
Next week ಬೇಡ ನಿಮಗೆ ಡೇಟ್ ಮತ್ತೆ ನಿಮಗೆ ಕೇಳಿದ ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
The state has a stay, what is the problem? After vacation, give a date. Though the matter has been listed for hearing, the appellant is not ready today to argue the matter. The appellant in writ appeal 731 is not ready today to argue the matter, list on. Give a date. Yes,
Page 10, it's number 4. Page 11, 5 to 7. Page 12, 8 to 9. Page 13, 10 to 12. Page 14, 13 to 17. Page
Serial number
16.
number 17, my lord. 15, 2 weeks time may
Yes.
be granted. Serial number 15, my lord. Council.
appeal admitted. Non-filing of
inconvenience.
acknowledgement for having served copy.
Please.
Week's time,
Please,
15.
My lord, serial number 17, my lord. Appearing for appellant, my lord.
Just a moment. Notice has to be taken in serial number 15.
please, my lord.
5606 days of delay.
Only one government
take
is there. We have already served. We have already served to the government. my lord.
Notice is not
Special
ordered.
land
counsel.
acquisition.
Yes. So and so the additional government advocate takes notice on behalf of the respondent. List after 2 weeks.
Good, much.
Yes.
My lord, serial number 17, my lord. Appearing for appellant, my lord. I will comply the top is objection, my lord. Some objection is there in the paper book, my lord.
Yes, 2 weeks time.
Much obliged, my lord.
Page 15, 18 and 19. Page 16, 20 to 23. Page
21,
17,
my
30
lords. With my lord's permission, serial number 21, I appear for my
Paper
colleague.
book.
21.
Non-filing of paper book.
Yeah, please, I appear for my colleague Gangireddy. 2 weeks time could be granted.
2 weeks time at the request for doing the leave. Yes,
Much obliged.
Page 17, 24 to 28. Page 18, 29 to 32. Page 19, 33 and 34. Page 20, 35 to 38. Page 21, 39 to 42. List 1, admission, 1 passover, syllabus 2. Lakshmikant Arya.
My lords say.
My lords, I appear for the respondent, my lords, competent authority. My lords, small submission, my lords. The same order passed by the special court has been challenged by separate 2 other orders, my lords.
Hmm.
The 2 other appeals may be clubbed with this matter, my lords.
yes, learned counsel for the appellant seeks a short accommodation on the ground that he's filing wakalat in the matter today. List along with,
MFA 8567 of 2022, my lords.
Hmm.
And MFA 3581 of 2022, my lords.
yes. Those are also have not been admitted.
No, my lords.
All the matters closely have been.
Here also notices gone. Yes,
Pre-adjourn, number 4.
For the respondent numbers 6 to 8 and 10 and 11.
instead of synopsis, the wakalat is. Let me see, what, for wakalat also wakalat is. And no memorandum of written. No certified copy of order. What are you doing? They're saying they're uploading. Nothing is happening. Yes,
Fifth respondent, we are filing an application for, we bring a LS on that.
Laws of whom?
Fifth respondent.
Therefore, 6, 7, 8 and 10 and 11, your lordship, in this case.
The respondent has died on. 2023.
Hmm.
Before she died, said that she executed a deed in favor of her landlord. That is, her name is Roja. We have taken a handsome to that. Handsome.
So, refused.
They have received.
Deemed complete. We can.
Filed an endorsement to that. On 13/11/2020.
Sort of order. 2/12. 12/24. Deemed complete.
There is one more idea. To bring some subsequent purchase of that is proposed responding number 13. The IA was filed on 12/3/2025.
Not there.
Kindly.
So hand summons issued in respect of R5, or
Second, IA is there,
bringing LRs of R5.
not listed.
Before she died, she has executed a gift deed in favor of her
Dispute
granddaughter.
wide order dated, dispute wide order dated,
1 of 25 they are filed.
wide order dated 2/12/2024. Ordered to, ordered hand summons to, the LRs of deceased R5,
R5.
deceased R5. The, accordingly, therefore, it is the hand summons served to the,
Yes, sir.
served hand summons to our deceased R5, LRs of deceased R5. In spite, she remained absent. Hence, service held sufficient to the LRs of deceased R5 held sufficient. Yes, accordingly, IA 1 of 2023 is allowed. IA 4 of 22 shall be called along with the time of hearing.
1 of 25, notice has to go
1 of 25
to propose respondent.
issue notice.
There is only one.
That is allowed, amend ಮಾಡಿ.
That is allowed. ಅದೇ
I
ಅಲ್ಲ.
will amend.
ಹ್ಮ್.
This will file one more application, 12/3/2025.
ಅದೇ ಅದೇ. Issue notice. What is it? Huh.
Notice has to,
I'm pleading application.
notice has to go to the
Notice
proposed,
has to go.
notice has to go to the proposed,
Kindly have, issue the handful.
Issue notice. Additionally, learn counsel for the appellate is permitted to take handsome action. Additional, yes.
Five,
Sure,
Girish
correct,
TR.
my lords. I'm for the appellants in this case. Lords,
B Kharab land,
yes, my lords. We can-
grant rejected.
Yes. But my lords, I am relying upon one amendment.
Hmm.
My lord, which is
Amendment to,
amendment to Karnataka Land Revenue Act, my lord.
what is the amendment?
My lords, page number 142, annexure R1. This is the amendment.
Yes.
I have produced it in my writ appeal itself. My lord.
Hmm.
My lords, in this case, my lord, the landlocked government land is in the middle of my property, my lord.
Hmm.
12 guntas, my lord.
That belongs to none.
That,
Belongs to all.
that which belongs to none belongs to all. Yes.
Let's kindly see page number 162, annexure T, which is sketch I have relied upon, my lord.
Hmm.
My lords,
Which is the B Kharab in this?
my lords, in the top, my lords, there is
L bar 7.
12/7, my lord.
Hmm.
There is a lines.
Hmm.
That land, my lords, it's a Kharab land.
Hmm.
Around that line, my lord, there is a private property. It belongs to me, my lord. Here, my lord, there is no lake, my lords. May I submit, my lord?
There is a clear road.
Road. No, my lord, this is the road. In the right,
Yes.
in
there is
12/7, my lord.
clear road access for the Kharab land. It is
Hello.
not landlocked. How do you say it is landlocked by your property? It's not landlocked. What is the finding of the
My lords,
revenue authorities?
my lord, except in annexure R, my lord, revenue authority recommended for grant, my lord. No, my lord.
Who has to grant? It is for the government to consider.
Government.
The government has considered and said that it cannot be granted.
It's a big Kharab land.
How can there be a mandamus to grant B Kharab land in
No,
your
no,
favor?
madam. I have challenged the annexure R.
What is wrong with annexure R?
In annexure R, my lord.
What is the provision with regard to grant of Kharab land?
Yes.
Grant of government land.
I have applied.
It is the absolute discretion of the government.
Yes, my lord. No point of time.
How can we enforce a discretion when you don't have a right?
But application was rejected, my lord.
Application was
But there is
rejected.
no and my contention, my lord.
All that is applicable when you have a right. Here is a case where absolute discretion is vested with the government. It is government land. Whether they want to grant it or not is in their discretion. They say it is not landlocked. Therefore,
No,
they
my lord. I have urged one of the grounds in my appeal, my lord.
even your
No, my lord. Kindly see the
sketch
sketch.
as such shows
Please,
that it is
please,
not landlocked.
kindly see the cannot be sketch, my granted at lord. any point of time, my lord. Kindly see the sketch, my lord.
Landlocked.
My lord.
Yes.
12/7.
Hmm.
In the first portion, my lord, there is a
Hmm.
in the upper, my lord, there is also private land. In lower to the Kharab, my lord, there is also private land. And there is no, my lord, my submission, there is no water bodies, my lord, there.
Well, that is
Well, it's-
immaterial counsel.
well,
This is not a case where you have any right to say that land should be granted to you. It is the complete discretion. They say in public interest, they're not granting. If it is granted to somebody else, you may have a case. They're not granting it.
And one more.
They're resuming it.
one-
What is wrong with it?
One more aspect, my lord. I have urged in my appeal, my lord. At least, my lord, there may be a permission to shift that that Karab. Because it's in the middle of my
Please show
property.
us the provision for shifting of Karab.
No, my lord.
Please show us the provision.
My lord, kindly have it at 2:30, my lord. Let me explain it.
Yes. 30 hours.
Please.
Pass
At the request of the learned counsel, pass over.
Hearing on IA. Bill number 6. Vijay Krishna Bhatt.
The advocate for the fifth respondent.
Respondent number 1.
I've
Bring for
25 days.
respondent 6A, my lord.
I filed an application to implead LRs of fifth respondent.
Already on record.
I have filed the wakalat and I've also filed the application and the wakalat of fifth respondent LRs.
Yes.
Yes.
On the death of.
And it will
deceased
delay also may be condoned.
phone number 5, these 3 applications are filed. I 1 of 25. Bringing the last of deceased R5. IA 2 of 25 for CD of 22 days. In filing the abandonment application, accepting the deceased R5 already appeared to their counsel, the applications are allowed. Accordingly, the counsel is committed to amend the cost type.
And I
Filing delay can be condoned
Filing
25 days.
yes,
Everybody is
Yes, filing delay can be condoned, alva.
yes.
Next, on order on IA 1 of 13. IA 1 of 13 Alakoli, accepting the reason assigned in the affidavit accompanied to IA number 1 of 13, the delay of 25 days in filing, which appeal is hereby condoned. Accordingly, IA 1 of 13 is allowed. Yes, list this appeal for hearing.
Yes.
Kindly fix it in April.
April any date,
3rd week.
March of it.
Much,
Week of April.
much.
16-4. Bill number 7. NS Bhatt.
In this case, I am appearing for applying. The respondent number 9 died and notice served. And so far as steps is concerned, my lord, R6 died. His wife is already on record. Kindly treat her as a alarm. I have filed memo. I am filing memo.
R9, this is
This is
R9.
R9. He is the purchaser. Please. This is on steps for steps R6, my lord. R6 died. His wife 10 is already on record.
there. Served, also.
Served, alva.
Maybe allowed.
Accepting allowed. First, madam, accepting the caution in the affidavit and already on record, since they are already on the record and represented by counsel, the IA so and so. 2 of 20, 4 of 24 allowed. Yes, issue.
Take steps.
No. 6 R6, they are already on record.
Steps are there, told by the. What is the reason? R10 is the LR of R6, memo file not placing reliance on memo. Learned counsel for the appellate files a memo stating that the respond number 10 is the LR of respond number 6.
Six.
Placing reliance of the memo, the R6 is treated as R6, R10 is treated as the LR of R6. Counsel for the appellant is permitted to amend the cost title to.
I may be permitted to carry out the amendment, miss.
Allow,
Amendment.
carry out the amendment.
Eight. RV Jaiprakash.
Copy was not served, it appears.
Has been served now?
No.
Has been served.
Only apprehension is, my lord, they are putting up construction. Suit for partition has been decreed. One of the items, my lord, it has been a part of the property has been acquired. Amount, my lord, deposited by LAO has been withdrawn by them during the pendency of the appeal. One IA is filed for praying for direction to deposit the amount. Another IA is, my lord, restraining, my lord, praying for a direction to restrain the appellants, my lord, from putting up construction in item number 2. I have produced the photographs also.
During the pendency of the appeal, they put up constructions, it will probably accrue to your benefit.
They should have, my lord, in all fairness, they should have sought the permission. There is a stay of drawing up of final decree proceedings. They should have sought, my lord, permission.
They are putting up the constructions at their risk. They
Amount,
will not be. able
let
to-
them file their objections. So far as amount is concerned,
Are you, as a matter of fact, putting up these constructions?
we have produced the photographs.
You are putting up the constructions.
I don't
You're-
know, I don't know.
You are ready to take the risk. Yes.
I at the request of the counsel for the appellant.
Meanwhile, my lord, let them some protection, my lord. Let them have withdrawn, my lord, the amount without permission from this honorable, putting up construction without permission.
Was heard on. For final hearing.
Meanwhile, some protection, my lord.
The matter is adjourned. Then understanding that the same would be taken up for final hearing. Re-notify on. date
Not-
ಕೊಟ್ಟು.
Now they have withdrawn the amount, some.
ಆಯ್ತು 2 weeks ಅಲ್ಲಿ final hearing ಮಾಡ್ಬಿಡೋಣ. ಆಯ್ತು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
8 April. 8 April. 8/4. 9 Shivram Bhatt. R2 may be allowed.
R2 date. 2019.
Already. R2 already in record, huh? Yeah.
No, I have.
No, that IAs are there. Yellow.
R2, A2, 3 are three.
In both cases.
Both the cases.
ಅಲ್ಲ,
Common
B2T
response.
civil process bias ಅಂತ
He has already entered appearance.
LRs have been represented.
LRs were
Represented.
represented.
Hello.
Yes, yes.
Application will have.
Applications, since the LRs of R2, that is R2, B2B, B2D.
A2D.
Yes, appeared and represented to their counsel, Mr. Silip Prasad Payas, for the accepting the cost shown in the affidavit. IA 1 of 22, IA 2 of 22, and IA 3 of 22 are allowed. Allowed. Amend the
Same,
counsel.
same.
Yes, yes.
In the other
Permitted
appeal
to
also.
amend the cost item. Yes, yes.
R3 has no.
R3, my lord, she has embraced the path of sisterhood. She has renounced the world.
There is, and she passed away also. So
R3.
the memo can be recorded.
Memo, what is memo?
Hakotai,
Again.
it is on record.
Memo is already filed.
Yes, yes. Placing reliance on memo. Madam, ಇದನ್ನ ನೋಡಿ. Now the word. Yes, the placing. Yes, placing reliance of the memo filed by the counsel for the appellate.
Along with
comma,
death certificate.
in respect to the death of R3, the is permitted to carry out the necessary
Yes.
amendment in the cost. Yes.
In RFA 1864, R4 also has died and R4's LRs are also
Yes,
on record.
on record.
Same.
Same order, same order. Allowed.
R4, R2, R3. Yes.
The council ಮಾತ್ರ R4 to R4 A to C represent this council Mr. Sridhar ಅಂತ. Yes.
Date may be fixed, madam. Old man.
Admit ಆಗಿಲ್ಲ.
ಆಗಿಲ್ವಾ?
It's not yet admitted, my lord.
Third admit, yes. Third admit. Record ಬಂದಿದೆ? Registry is directed to secure the trial court records.
Date may be
Yes,
fixed, my
list
lord.
for
Partition
here-
suit, my lord, between the family members. Date may kindly be fixed, only request.
Admit.
Paper books.
Paperbook.
Is there any chance of settlement
They are.
between the parties? Yes.
Yes, my
That's
lord.
why we are asking, is there any chance
We'll take a chance.
you can?
Mediation Center, Bangalore.
ಮಂಗಳೂರಿಗೆ ಅದು ಮಂಗಳೂರಿಗೆ
Petition said refer ಮಾಡುವ.
ಮಾಡ್ಬೋದು. Maybe referred man.
Yes.
The party is willing to settle.
But the both of the respective.
Yes.
The party is willing to settle.
Party submitted, there is a possibility of settlement. And in this case, as such, the matter is.
Any date?
Third.
At 3 o'clock or 3 p.m.
3.
Yes. Yes, yes.
10, Gautam Dev. ಮಾಡ್ತೀರಾ? Ten, Gautam Dev.
EDA.
Mike.
My lord, originally, my lord, this is the submission of BDA is that the petitioners, it is not even the petitioners, my lord. Original Katedar, my lord, had approached this honorable court by filing a writ petition, my lord.
This is BTM fourth stage.
BTM fourth stage, my lord. The original Katedar had already approached this honorable court by filing a writ petition, my lord. And then he suffered an order at the hands of this honorable court. And it was part of a reported ruling by Lordship N. Kumar, my lord, where the entire layout was held to be implemented, my lord. Entire Devara Chikkanhalli was held to be implemented. Then then thereafter the petitioner, the original Katedar, again approached the honorable division bench of this honorable court and filed a writ appeal, my lord. There also,
11.
on the ground of lapse, my lord. Then there also, the honorable High Court dismissed their writ appeal. Then they went to the Honorable Supreme Court, my lord, once again. That also I have produced, my lord. That order I have produced as Annexure 8, my lord.
Annexure 8 along with your.
Yes, my lord. Affidavit, my lord. The original order passed by this honorable court, I have already produced in my, along with my writ appeal, with additional documents, my lord. As additional document I had produced, my lord. Page number, Annexure I, my lord. Application under Order 4127, my lord, for production of additional documents. Page 125, my lord. My lord, 40151 was their writ petition, my lord.
40.
151, my lord. Page number 127, my lord.
0151.
The petitioner is,
Muniappa.
yes, my lord. T.
Muniswamy
Muniappa,
Yellappa.
a son of Topu Muniappa. Topu Muniappa is the notified Katedar, my lord. Then they filed, as a group, they filed a writ petition, my lord. And then it was a detailed order, my lord, where this honorable court considered the entire my lord, extremely sorry, my lord.
40151 of 2002.
My lord, the operative portion of the order, my lord.
There is substantial execution.
Yes, my lord.
proceed.
Even the,
Has
yes,
been complied.
yes,
with.
my lord, and the affidavit of, in the page number 146, the entire, the challenge to section 27, my lord, lapse, that is a lapse provision, my lord.
Hmm.
And that has been considered, my lord. And then how much layout has been formed, how much compensation has been deposited, how many sites are formed, everything is discussed, my lord.
Particularly village.
Yes, my
2
lord.
acres, 9 guntha.
Yes, my lord.
Acquired for BTM fourth stage under final notification 3/11/1990. Award passed on 15/11, approved on 25/1, possession taken on 14/2, handed over to the engineering section for formation of layout. Layout has been formed with 1,470 sites, out of which 1,210 sites have already been allotted.
Yes.
This is recorded in the earlier.
Yes, my lord. And then on the basis of this,
Hmm.
the honorable court dismissed this writ petition also, my lord.
2003. Yes.
Then, my lord, the writ appeal has been filed, my lord, as I pointed out, my lord, kindly. The same persons challenged writ appeal, my lord. That
Page
is one, my affidavit, my lord, along with my affidavit, page number 43, my lord.
Page number?
43, my lord. There he is, second writ appeal, my lord. In the order situation, in the front, second serial number 2, page number 43. my lord. My affidavit. My lord.
Hmm.
Madam. There they challenged writ appeal also dismissed, my lord. Then they went to the Honorable Supreme Court, my lord.
Hmm.
Then there also their case was dismissed, my lord. Though it
This is in respect of the very same property.
very same property, my lord. This is by Venkatesh Reddy, my lord.
Hmm.
And that is a batch of writ challenging the very same
Hmm.
in orders, my lord.
Hmm.
Then the Honorable Supreme Court also dismissed the page number 96 and 97, my lord. My lord,
Only 84 records.
84 pages.
my lord, sorry, my lord. This is the document.
Page number 84 or 90?
This is the document.
Page number.
This is the document.
Document.
Same I submitted to the
I
court.
don't think document is here. This is respondent's documents. Where is the appellant's documents? Has it been filed?
Yes, my lord, it's there. The file.
The file already.
Yes, ma'am. I filed there. I got the seal also.
When is it filed? 21/25. So, 21/25, there is nothing there.
This is the one.
Yes.
ಇದೆ ಕೊಡ್ತೀನಿ.
96.
Yes, my lord. My lord, page number 43 may kindly be seen, my lord. There, the cost title will be here, my lord. Those who.
That is when.
There, my lord, that is serial number 2. Second is the same persons, my lord, Topo Muniappa. Then after considering detailed submissions, my lord, the honorable court dismissed their writ appeals, my lord. Then a challenge is made to the same order before the honorable Supreme Court, my lord. In page number 96, my lord. Then there also they have suffered an order. Suppressing all these facts, my lord, they approached the learned single judge, my lord. Didn't inform anything about these proceedings, my lord. And there, one more aspect is, they don't claim how they are related to these persons, my lord. They never filed any genealogical tree, any identity card, nor any document to show their LRs of these persons. They simply say Yellappa, my lord. And if the cause title of the writ petition is seen, my lord, the cause title of the writ petition is seen, my lord. They say Yellappa, late Muni Yellappa, my lord. Petition, page number 28, my lord. They say Venkatesh, son of Muni Yella. Then S. Manjunath, son of Muniappa. They don't produce any document to show their LRs. How they are related to that persons, they don't show, my lord. Nor do they disclose the fact that there was a order, they approached, the legal heirs approached the Honorable High Court and they suffered an order. That is nothing but, my lord, suppression of material facts.
What is the scheduled property in this case?
My lord, scheduled property, page number 37, my lord. All piece and parcel of survey number 29/2, 27/1, survey number 37, measuring 1 acre 2 guntas, 2 acre 1 guntas, and 2 acre 3 guntas of Devara Chikkanhalli village, Begur Hobli. One more aspect, my lord, is, my lord, same survey number, my lord. There are so many people who are claiming we are the owners, my lord. That can be seen, my lord. Page number 149 of the writ appeal papers, my lord. There are about 100, about more than 80 to 112, my lord, more than 140-50 people, my lord, claiming in respect of the same land, my lord, and the same learned single judge who passed the order, impugned order, my lord, has considered their claim also and directed BDA. They also told the same thing, lapse and other things, my lord, but the honorable same learned judge didn't quash the proceeding, but directed BDA to consider the representation, my lord. The survey numbers are mentioned in page number 171, my lord. Same survey number, my lord.
The creation schedule 24
180 people, my
24 bar 3, 25 bar 1. Here also 27 bar 2 is there.
Their learned single judge directed BDA to consider their representation only, my lord. My lord, first our submission is these people have not proved that they are legal heirs. They are third parties, my lord, to the so far as BDA is concerned, my lord. Second is they are guilty of suppressing material facts before the learned single judge, my lord. Third aspect regarding the on merits, my lord, regarding implementation of the scheme, my lord. This particular layout, my lord, we have produced affidavit before this honorable court showing that a tender has been called for so far as forming of sites in that particular particularly that survey numbers, my lord. And then we have also allotted sites to so many persons, my lord. I have produced the allotment details. Then these persons, my lord, who are all owners, they threaten the land owners, the site owners, my lord, and they are chased away. Then they come to BDA and ask for alternative site, my lord. Then we have given them alternative site. Because of that, it remained vacant. Because of the pendency of the court proceedings, my lord. During that time, my lord, before the sites were formed, we have also formed a layout We have formed drains. We have installed electricity poles, tarred the roads. But over the period of time, my lord, some trees and other developed because long pendency of the dispute. Taking advantage of that, they are claiming that the land is vacant and it has not been implemented. Therefore, there is a lapse of proceedings. My lord. Once the scheme is implemented, my lord, there is no question of lapse of proceedings. I have also produced, my lord, the sites, the allotment book also, my lord. I have produced the allotment book before this honorable court, my lord. And my lord, in fact, in one of the
Why was none of this even attempted to be raised before the learned single judge?
My lord, sometimes what happens, my lord, even the BDA, my lord, we would not have been informed about the, it has happened, my lord, sometimes. We are not in, even the advocates may not have been knowing about it. We had to search the entire records, my lord. Then when the records are seen one place, we saw the order, my lord. Then we extracted all the things and found out that. Then when this honorable court directed us, we also collected all the documents. Even in the assembly, this is discussed, my lord, saying that there is a huge fraud and officials are hand in glove and so many things are alleged. Now it has become a huge dispute, my lord. So we are clearly revealing all the. Now, my lord, when our commissioner, my lord, when visited, also collected all the pictures of the said site, my lord. I have produced this, the same before this honorable court, page number 314, my lord, with the Google location. My lord, with the Google locations, my lord, of survey numbers. There are kind of. My lord, that is the problem. Lot of public wealth is invested on that particular property, my lord. No,
You only consented before the single judge?
my lord, not even it is their duty also to reveal the facts to this honorable court, my lord. It is not the honorable Supreme Court says it's the first duty of the petitioner to reveal, then we can respond. Once they reveal, we can respond. They don't reveal anything, then we also suffer the order, my lord. Then we are.
The contention specifically was that the land possession had not been taken.
Yes.
If that was not the fact, why was it not brought to the notice of the learned single judge is the question.
Yes, my lord. That is not, that has happened in this case, my lord. Now we are bringing the facts to this honorable court, my lord. My lord, I have also produced the map, my lord, of the layout map, annexure I, my lord. That is 14, page number 324, my lord. The yellow portion, my lord, is the layout form, my lord. Total layout form. The red portion is the places where sites are already formed by the already developed areas, my lord. So we have given up that areas, my lord. And my lord, may kindly see that, my lord, the blue color, my lord, is the portion where in the X that T type of land, my lord, next to 4, my lord. That is the subject land, my lord. Yes, my lord. Below 3 also, my lord.
These are separate pockets of land according to you.
My lord?
These are separate pockets of land.
No, my lord.
According to you.
This portion, my lord. This portion and this portion. my lord.
Yes, which is why we are saying they're separate pockets.
Yes, yes. My lord, there are site holders there and some of them are residing in that property, my lord, especially 37, my lord. They have not made any parties, those people, those allottees, my lord. There are buildings also constructed there, my lord.
Yes. Who appears for the respondents?
Yes, Lord, I am appearing for.
What do you say?
Lords, what my learned friend doesn't tell is before your lordship gives this layout plan, just have a look at one part, Lords, here. Now, this is layout plan prepared only for court case purpose.
Sorry?
This says layout plan prepared for court case at the top, just to mention it, Lords. This is not the layout
Assist
plan
this
of the
honorable
scheme.
court. So, assist
Layout
this
plan of
honorable
the
court
scheme,
to
Lords.
review particular-
But purely something prepared for court purposes. And what, my lords, your ladyship is absolutely right, my lords, and my lords also, my lords. To say this, my lords, that this is the first time all these contentions are being raised here. Nothing of this was before the learned single judge. My learned friend or his colleague, my lords, appeared, which is so recorded in the impugned order. And lords, my lord Justice Rai, my lords, has been lords, party to several, my lords, orders, at least one of them, my lords, whereby, my lords, on identical situations, my lords, your lordships have held that the scheme has been abandoned for the land of the petitioners. Because I filed an entire series, my lords, starting from Huchamma, my lords, which has been relied upon in the impugned order, my lords, by the learned single judge in the present case. If your ladyship will find, my lords, this compilation was filed on 15/7/24, which also contains, my lords, the series of judgments starting from Huchamma. In all these cases, my lords, just for 1 minute before your ladyship looks at it, my lords, and your lordship, my lords. My lords, all of these are subsequent, my lords, and they go up to the Supreme Court, my lords, whereby it has been held, my lords, that where compensation has not been paid to the landowners, which has not been paid to me, my lords. It is their own case in the appeal, or, my lords, possession taken, my lords, the scheme will be held to be abandoned for the landowners, my lords. So, my lords, if I may take your ladyship, my lords, and your lords, my lords, let it be say my lords to make it easier, my lords. With the diversity, my lords, I'm grateful, my lords. We land up into this situation, my lords, once in a while. So, my lords, if your lordship would take up, my lords, page 9 of this compilation. This is the judgment on which the learned single judge in my case, my lords, relies upon, Huchamma, which is travelled up to the Supreme Court and upheld, my lords. Now, there's parity also. We can't, my lords, be doing this, my lords. If your lordship will see, my lords.
Huchamma is dated 15 September 2017.
Yes, my lords. And if your lordship should find, my lords, paragraph 3 at page 11. The main contention urged by petitioner in support of the relief sought seeking declaration that acquisition proceedings have lapsed is that the acquisition was not completed by taking over possession and by paying compensation to the petitioners. In this regard, he points out that though the award was passed way back in the year 1994, so far admittedly compensation has not been paid either to the landowners or deposited before the civil court. To substantiate, my lords, there are certain documents, my lords. I won't bother your lordships into that, my lords. But it is established that compensation not paid and possession not taken. Paragraph 6, my lords. Having heard the learned counsel for the parties, I find that it admittedly a award has been passed as back on so-and-so. So far, compensation has neither been paid to the landowners, petitioners, nor deposited before the civil court. As rightly contended by the learned counsel for the petitioners, there is no legally acceptable material on record to show that possession of the land has been taken. On the other hand, petitioners have produced RTC extracts for the years 2015-16 at Annexure A, which shows that the land is still recorded in the name of the petitioner, Huchamma, both in column so-and-so. In similar circumstances, this court in WP so-and-so has held that if compensation was not tendered or paid, it would not satisfy the requirement of payment of compensation so as to complete the acquisition proceedings, and that such conduct on the part of the beneficiary would tantamount to abandonment of acquisition. The observations made in paras 11 and 12 in this connection by referring to the judgment of the Apex Court in the case of Illegal Development Authorities extracted here in below, my lords. And this, my lords, in this, the finding of the court, my lords, at page 15, line 7 from the bottom, my lords, approximately. Therefore, at page 15, my lords. Therefore, the BD has consciously chosen not to take possession of the land, pay compensation or form layout in the land belonging to petitioner, which is the subject matter in the present petition. It is not the case of the BDA that it has formed the layout and allotted sites to third parties. Therefore, the irresistible inference is that BDA has abandoned the acquisition with respect to these lands. Well, it's even now what my learned friend was trying to say was, which is a new fact raised for the first time in the appeal, is that alternate sites were allotted to some. So these sites are not allotted. Their own statement saying compensation has not been paid to the landowners. It was
With respect of the lands in question. What do you say?
my respectful submission is twofold here. A, my lords, yes, I have not said so. But my lords, these petitions are filed by my fathers and through power of attorneys. And your lordship knows, my lords, in these agricultural matters, my lords, and acquisition matters, what transpires is a batch of them get together, my lords, power of attorneys done, my lords, in the first instance. Neither did the BDA, my lords. I don't wish to put the burden on them. I'm saying I could not because I did not have knowledge. And that is my only stand. I go no further. I can't. But thereafter, my lords, there are a batch of all these judgments, my lords, in this compilation which I have filed, including my Lord Justice Rai was a party to one of the judgments, my lords, in the division bench, whereby
No,
Well,
one
and
is
this-
in respect of the very same lands.
no, not in the same lands, my lords, but all adjacent lands on the same principles.
No, on the very same lands.
Yes,
Once there is a finding
yes.
that the layout stands firm, how can you maintain a second writ petition
Well, it's
with regard to the very same land without disclosing what happened earlier?
well, it's my non-disclosure is based upon my non-awareness. I can only say this, my lords, because it is not me who has filed it. It is my forefathers who filed it. Through power of attorneys, it is so recorded. Also, my lords, what is the position is, my lords? What happens is, my lords, today, if some wrong fact, my lords, the scheme the layout has been done or the scheme has been implemented. In fact, what my Lord Justice Nazir was the counsel, my lords, in that matter those times, my lords. He made a statement that was so accepted. It is incorrect. My Lord Justice Bhagwati's judgment, my lords, which I'll show to your lordships, my lords, ultimately says, my lords, if something is based upon a wrong fact, my lords, and there are a series of judgments today which hold that in the same scheme adjacent. So, my
The
lords,
parties that has become final.
my lords, may I say one thing?
Can a successor in interest say that you're not bound?
Page
Well, it's-
24, you
yes.
can read the judgment of the High Court.
Well, lords, may I just read
In
the
respect of the
judgment of the
same
High
survey-
Court in
same-
this
same
same survey number?
Survey number 20.
Same survey number, though not the petitioner's lands. May I just show your lordship? Same survey number. Page 40.
Page 24.
Sorry, page 24.
24.
Shantamma's case
Different
in
history.
the same series, my lords. This, my lords, is starting from here, my lords. This is the judgment of the learned single judge, my lords. And the same khasra, if your lordships will see, my lords. Serial number at page 27. It is so mentioned. I'm sorry. It is so mentioned, my lords, on page 27. Khasra, serial number, survey number, I'm sorry, my lords. 27 bar 2 of the same village, my lords. It has been so held, my lords, and it is held to be lapsed. I appreciate what your lordships are saying, my lords. But today, my lords, your lordships have to reconcile this position. Coordinate benches of this court, my lords, in one matter, not one matter, in about 7 matters, have held.
Your matter.
Yes,
This is the contention.
yes,
Unless you can tell us otherwise.
yes.
Your matter in respect of your property, matter has traveled up to the Supreme Court.
Yes.
It has been affirmed.
Yes,
If that is so, the second writ petition on whatever the facts, your contention that the adjacent landowner has a judgment may not help you.
well, it's, your lordship
Not
is
help
quite.
you unless you can explain how this comes about.
Well, it's, what happens is, my lords, what was argued in that petition, my lords, which of course I again reiterate at the cost of repetition, that I was not party to those petitions filed through power of attorneys, nor was I there at all. But be that as it may, my lords, of course, I am down in the lineage. My lords, may I just proceed further? I'm not stopping there, my lords. I'm not stopping at that point. But I'm saying, in addition to that, my lords, what transpires is, my lords, in that case, my lords, what has been recorded is wrongful. That the scheme has actually been implemented, the subsequent orders of this court, coordinate benches record. Well, let's, in that respect, I'm sorry, my lord. I should not, I'm sorry, my lord. Would your lordship, let's please say.
No, a finding of fact.
Yes.
Which is recorded in a particular case
Listen,
and which has traveled up to the apex court. Can we do anything about it, even if you show that in respect of the very adjacent property, there is a judgment, if it is in respect of the very same property, we'd say we are bound, and whatever has happened before the learned single judge, because of the BDA not placing the facts, cannot make any difference to the situation.
Well,
If it is in respect of the very same
I
property,
appreciate.
that would be the end of it according to us.
Yes, may I just point out to your lordship, was a judgment of the Honorable Supreme Court, my lords, in Bangalore, who the judgment? Which one? The court. This is Bhagavathi judgment. In, my lords, a case of distributors, where, my lords, if there are wrong facts, and on that basis something has been passed, my lords, the lordships have held, my lords. May I just show this? Justice Bhagavati's judgment in distributors, Baroda, my lords, versus Union of India. This would come on, my lords, page 32, my lords, running page. I'm reading the relevant part, my lords. Para 19. This is totally wrongful. Till date, my lords, the position remains no compensation, no tendering, no possession, and I'll just show those documents. They were not there before in the earlier date, from what I understand. The records are also not available, my lord. But even so, in our view, has your lordship got that? No, sir? The decision in cloth traders case is erroneous. The question still remains whether we should overturn it. Ordinarily, we would be reluctant to overturn a decision given by a bench of this court because it is essential that there should be continuity and consistency in judicial decisions, and law should be certain and definite. It is almost as important that the law should be settled permanently as so that it should be settled correctly. But there may be circumstances where public interest demands that the previous decision be reviewed and reconsidered. The doctrine of stare decisis should not deter the court from overturning an earlier decision if it is satisfied. Has your lordship not got the page, my lords? Page 32. If it is satisfied that such decision is manifestly wrong or proceeds upon a mistaken assumption in regard to the existence or continuance of a statutory provision or is contrary to another decision of this court. It was Jackson judge who said in his dissenting opinion in Massachusetts, I see no reason why I should be consciously wrong today because I was unconsciously wrong yesterday. Lord Denning also said to the same effect when he observed in Austin versus Australian Mutual Provident Society, the doctrine of precedent does not compel your lordships to follow the wrong path until you fall over the edge of the cliff. Here we find there are overriding considerations which compel us to reconsider and review the decision in cloth traders case. In the first place, the decision in cloth traders case was rendered by this court on so-and-so, and immediately thereafter, within a month, introduced section 80AA with retrospective effect from 1st April 1968 with a view to overriding. The decision in cloth traders case did not therefore hold the field for a period of more than few months, and it could not be said that any assessee was misled into acting to its detriment based on that decision. There was no decision of this court in regard to the interpretation of subsection 1 of section 80M prior to the decision in cloth traders case, and there was therefore no authoritative pronouncement of this court on this question of interpretation on which an assessee could claim to rely for making its fiscal arrangements. The only decision in regard to the interpretation of subsection 1 given by any high court prior to the decision in cloth traders case was that of Gujarat High Court, and that decision took precisely the same view which we are inclined to accept in the present case. It is therefore difficult to see how any assessee can legitimately complain that any hardship or inconvenience would be caused to it if the decision in cloth traders case was overturned by us. If despite the decision of the Gujarat High Court, so the assignee proceeded on the assumption now found to be erroneous that the Gujarat High Court decision was wrong and the deduction, etc. If I may go down further on.
Can I?
Yes.
You for a moment and ask a small question?
Yes, please.
Would whatever is stated here
Yes.
affect cloth traders? It petition in
Yes, it does. As for the reason,
proposition
yes,
would be probably liable for correction.
what I was urging was that judgments are proceeding on a wrong as per court benches of this court in several decisions. The factum of compensation not being paid, not tendered.
In
and
somebody else's case, it can be considered.
Yes.
Not in the case which stands settled
Let's-
between parties.
let's- on a
This is
question
our
of-
understanding of the law. We can probably, you can please get instructions as to how this comes about. Second, they're also correct in one sense that there is a batch of writ petitions which have traveled up to the apex court.
Yes.
now to say that we are the persons in possession? How?
Milords, may I just show your lordships just to satisfy for a moment, and then
Yes.
I'll go back to Milords the same address, Milords. So Milords, let me straight away show your lordships, Milords. The fact that I am in possession and the records so indicate, and also the fact that BDA in its own documents in other proceedings have shown, Milords, that the scheme is not substantially implemented as a matter of record. Milords, BDA also, Milords, is taking different positions in different courts, Milords. And therefore, Milords, even today they are saying, we could not find the records, we've come for the first time. So, Milords, it was not available for any discussion. The earlier judgment, Milords, does not even discuss these issues, no compensation paid or possession. So may I just show that to your lordship, Milords, from the current record, Milords, as to what is the position regarding, Milords, with no possession, Milords, having been taken and no compensation, Milords, having been paid. Straight away on the no compensation, Milords, for the moment, it is a own statement, Milords. At page 9 of the writ appeal, yes. So, Milords, may I? Yes. Milords, the current series of judgments also have travelled up to Supreme Court, though in respect of other lands, yes. So therefore,
What is the difference?
I concede straight away, Milords, I cannot possibly say something which is contrary to fact. So, Milords, now to show your lordships, now that the issue in question, so, Milords, for all purposes, that stands impliedly overruled. Milords, if the petitioner's land, same khasra, though not the same petitioners, that is held to be lapsed, compensation not paid, possession not taken, and your lordships would be, Milords, so inclined to say that there is, because of a prior judgment on another issue, therefore, I would be non-suited, Milords. Would, Milords, be totally inequitable, Milords, and lead
If
to
you had, as a matter of
discrimination?
fact, come before this court, said there is a judgment, and even in spite of that, they have not taken possession, and therefore it is, after the 2013 Act, it does lapse. If that were the
This is not
contention that-
2013. Today, your lordships have held, Milords, my Lord Justice Nazir's judgment only that BDA Act would apply and the Land Acquisition Act of 1894 will apply. So 2000, Milords, I have in fact done the Indore development before the
13,
Constitution.
there's no question of the 13 Act,
No question of that.
whatever.
Under 27 of the BDA Act, if the scheme is not substantially implemented, so Milords, what I'm saying is,
Therefore, the fact that you did not even disclose the earlier writ petitions and you suffered those judgments, I think
Milords,
that settles the issue.
no, Milords, may I say, that's what I was trying to
We
share.
hear you on this
Very well, Milords.
in
Well,
detail,
Milords,
because
I
this
appreciate it.
appears, once this is
appreciate it.
admitted, it's difficult to get over the earlier.
Yes, Milords, I'll also, Milords, go into the records of the earlier petitions to see if there is, Milords, a distinction point. But just to mention, Milords, my Lord's judgment also, Milords,
Earlier round of, fact remains, madam, earlier round of litigation, it's travel till Supreme Court and attained finality. Now, once again,
Milords,
it's a sheer negligence.
Milords,
on
it's
the
a
part of
peculiar
the state. That
situation.
we have to-
your lordship is right.
No, that has
Normally,
to-
Milords, we should go to Supreme Court and ask them to consider as to what has happened and therefore resolve the controversy. But since they are in limine, Milords, most of the orders, they've just been dismissed, Milords, there. So therefore, Milords, I'm unable to do that position. I'm also constrained, Milords, your lordship is aware, Milords, I can seek review of an order, Milords. Once a judgment is in SLP, Milords, been dismissed in limine, Milords, and it's open to me. So, Milords, today position, I'm in a peculiar situation where
For
my,
that,
yes,
for that, you should have disclosed that there was such a judgment.
Milords,
Without disclosing that there is such a judgment, when you're seeking the very same reliefs, then.
I have no answer. Except to say I did not have knowledge.
Completely different.
Milords, your lordship is aware, I'm sure, Milords, of these acquisition proceedings. There are all these batches, Milords, and these batches do lead into some difficulties, which I have put to your lordship. Milords, power of attorneys filing, forefathers filing, Milords, not to my knowledge, the records don't exist. But anyway, Milords, I'll come back on that, and I understand your lordship's Milords' anxiety on that. But the fact on record today, as per the BDA, is that out of 241 acres, only 114 acres has been given over for purposes of the scheme, which is left, Milords, much less than 50%. So I don't know, Milords, what the BDA stand is.
This is the situation. Then it would have been a complete. Why was this never brought to the notice of the learned single judge that there was an earlier writ petition and that this was the situation?
My lord, sometimes, my lord, this has led
These
to,
arguments on both sides
my lord, in fact, my
leaves
lord,
us in a situation. How can you say that when there is a specific writ petition, which is not one, it is a batch of writ petitions with regard to the very same layout,
My lord,
and
even
you
if,
say that there is a finding that it has been
my
substantially
lord,
implemented?
my lord,
Keep quiet.
even if you had filed objection, my lord, it would have been suffice. If the learned counsel, my lord, even if he concedes, if it is against the law, my lord, that will not bind us, my lord. And one more aspect, my lord, they are saying that possession is not taken. That is not possession in that term, my lord. We have taken possession. They say that possession is no possession because the master is not as per law. That is discussed in several judgments, my lord. Even award is passed.
When was possession taken according to you?
Possession, my lord, 6888, my lord.
That is defective.
In respect of
68?
sermon number 29/2.
6/8,
6/8/1988, my lord.
1988?
88, my lord.
Cannot be.
That's
3/11/1990 is
Because
the,
according to them, 94. Let me tell you, Lord.
Some land, my lord.
According to
There are
them,
three-
94.
There are 3 lands, my lord. There are 3 lands.
I see.
Survey
whatever that be, the final notification is on 3/11/1990. Award is thereafter. So
yes,
it can only be thereafter.
Yes, sorry, my lord.
It's not advanced
Sorry,
possession.
sorry, my lord.
Mm.
Apologies.
That's from their record, I'm
My
saying
lord,
it's 94.
9694, 9694, my lord.
Okay.
Then, in respect of survey number 29/2, my lord.
Mm.
In respect of 27/1,
Mm.
it is 8694, annexure D1, my lord.
Mm.
That is annexure D, my lord.
Mm.
And then, survey number 37, it is 25/894, my lord. Annexure D2, my lord, page
Mm.
79.
Compensation?
My lord,
Deposited.
deposited in the civil court, my lord.
Not paid, not tendered.
That because they won't receive.
Contrary to law, my lords.
We'll see.
Yes, I'm good. I'm good.
Please get instructions as to whether why none of this was.
My lord, it is a
ever urged.
conceding by advocate, my lord, it won't bind. If it is conceding is against the law, my lord, then
There is no
the
concession.
judgment, my lord.
There is
they-
no concession. You did not place the facts
Yes,
before the
we
court.
should have filed objection statement and what
Absolutely, you
it,
should
but
have.
sometimes, my lord, what happens, they will dispose of the matter, my lord, at that times, sometime it happens like this. my lord.
In any situation, like the landlords, the officers or the BD, let that erring officer be present here, next date of hearing, will inquire.
And let them produce the records, my lords, also of the, because today we are, my lords, in the dark. They place, my lords, layout plans which are part of the, only for court record. Let them place the Supreme Court also. So therefore, my lords, I would only urge this court, my lords, to let them have the records also available.
We will bring the records, my lord, and we produce in openly before the same records, my lord, we have Xerox
As
and.
to why it was not placed before the legislative judge also, we wanted explanation. In some cases.
My
we
lord,
say-
even in Supreme Court, my lord, it is not like they said, it in Sharadamma case, my lord, it went up to Supreme Court. Supreme Court gave liberty to file review before the Honorable Court, my lord. In some of the cases it has happened, in that cases also, in that batch which they produced. I've read that order, my lord.
Yes, it that be. So this is also a case which should go for review.
That's what I will say.
My lord, if we can also,
This is also a case which should go for review. You must raise this before the learned single judge and content so that they can also raise their contentions there.
my lord, I'll take instruction because we have, definitely they have suppressed, my lord. And they should also be accountable for that.
Yes.
my lord. And my lord, one more crucial aspect is they would definitely not know because according to what I feel, my lord, they are not even they are not even the legal heirs. There are some third parties who are taking luck, based on luck, my lord, to knock off some land. They are just filing writ petitions to knock off some government properties, my lord. There are some third parties who are not even related to the, some brokers or
Because
something.
I also filed, my lords, the lineage just to satisfy my learned friend.
Have you raised, please
I'll do
raise all that.
I'll
on the-
because let's not get into that because I'll file that.
How they are legal heirs, they should.
Yeah, I'll fail.
to the
I'll file.
court, my lord.
All this you should have
Should
raised
have been
at
taken
the
before the
time when the
single
writ
judge.
petition had been
They
filed.
should do it, my lord. They should plead it. Then we'll have a chance to oppose it.
When they file a writ petition and say that this project has, acquisition has lapsed, and you have a judgment in your favor which says that it has not, which has traveled up to the Supreme Court, is it not for you to raise that as the first contention? With regard to the very same acquisition, you say it has already gone to the Supreme Court, a batch of, not one writ petition that you could have overlooked. a batch of writ petitions which says that this layout is formed, substantially implemented.
My lord, what happened? They have observed only Huchamma's case and passed the order, my lord. That is all.
Counsel, have you raised it?
We have.
Have
also
you
not
raised any such contention?
We have also not raised, they have also not raised, my lord. That is the problem.
Yes, please, you are the appellant. Tell us why you did not raise it. You owe us an explanation first.
My lord, now we have.
Don't
raised-
worry about their explanation. That we'll take care of when we reach that. You are the appellant.
My lord, we
Yes.
collected the records and.
Yes, please produce the records and tell us why it has
My
not
lord,
been raised.
already we have produced all the records, my lord, before this on the bulletin.
Not a single record is there,
No,
not a single sale deed is there, not a single allotment letter is there, only some land registers they produce.
Filed affidavit itself.
No sale deed,
We have
not a single
produced-
word.
We have produced all the affidavit, including affidavit. We have answered this honorable court. That's just their general statement, my lord.
Convince us.
The land is similar to that
It is principally for the appellant to convince us that there is something wrong in and why it happened.
My lord, I didn't.
Yes.
Grateful.
What do you wanted?
Understand, my lord. I didn't understand. Sorry, my lord, I didn't understand. Just
No, we are saying that it is for the appellant to tell us that there is, that the judgment is erroneous and how this happened. How the
My lord,
fact that it was,
on the face of it, my lord, just prima facie, my lord, the same learned judge, a single judge, on same survey numbers. I have produced that document also. Has not, on the ground of lapse, some 180 people challenged acquisition. Then same learned single judge didn't quash the
the
proceedings.
question is this. There is a finding that it is not lapsed
Yes, my lord.
and that it is substantially implemented. Why was it not brought to the notice of the learned single judge? That is all we are asking. In respect of the very same layout, there is a judgment which is traveled, which would have been binding on the learned single judge. Was it raised before the learned single judge? Why? All that we need an answer to.
Now that lordship has expressed, we will answer
Yes.
that.
I'll also file all the lineage ones, just to satisfy on those aspects.
In the course of argument, learned counsel for the appellant submit that the earlier round of litigation already traveled till the Honorable Apex Court, and in respect to the very same subject and land in question. In such circumstances, the learned counsel for the VDA is directed to secure the original file, original record pertaining to the dispute, pertaining to
Scheme
this
in
land.
question, my lord.
Yes, scheme in question. And also he present the officer, concerned officer before this court, the next date of hearing, re-notify.
Concerned officer in the sense now, my lord.
Yes, yes.
Yes, ma'am.
Or at that point of time. It's left to you.
You can explain to us why this happened.
Copy of the scheme.
Yes.
7th of April,
Sorry,
7th of April.
could it be little later, my lords, if your lordship says convenience, 29th of April possibly,
29th is end of the.
end of the month? Any other dates? Just, I had some vacation, I didn't realize, I'm sorry.
Any nearest date will be.
Before. Wait, no. Okay, wait,
21st,
21st.
that week.
Wait, no. It's okay. The 21st is already.
21/4.
I'm so grateful, Milas. And laws will ultimately also consider whether it might be appropriate, subject to what your lordship hears, Milas, later. It will be appropriate to consider referring back the matter to this learned single judge, Milas, to actually consider
We'll see.
light of all the developments, Milas.
Let them.
I'm so
He
grateful.
will come.
My lord, fraud, my lord, fraud, my lord. If it is a suppression, at any stage it can be challenged.
Milas, could a copy of the record be available for inspection by us, Milas? Milas, could the copies of the record be available for inspection by us, Milas?
My lord, we
Of the
have
scheme?
given everything. my
It is for
In the-
the court to.
Very, very. Grateful, so great.
No notes. Only on the side of it.
11. Bagger BP.
My lord, I'm respondent.
Will not admit.
Lords, IA number
477 days.
Yes, my lords. My lords, the,
1477.
yes, my lords, the impugned order, my lords, was assailed, my lords, before the learned single judge, my lords, in the writ petition. My lords, the order passed, my lords, is on 29th January 2015, impugned order, my lords. My lords, and the writ petition, my lords, before the learned single judge, my lords, is filed on 11/3/2015. My lords, the writ petition, my lords, is disposed of, my lords, on 24th November 2020.
Last time the
On merits, my lords, it will not survive, but
settlement.
it's still ongoing, my lords. It's still on. Before the executing court, my lords, the judgment debtor, my lords, has requested, my lords, for an OTS with the decree holder. My lords, what has happened is, my lords, the order which is impugned in the present appeal, my lords, was also impugned, my lords, before the learned single judge. My lords, while passing, my lords, the final order in the writ petition, my lords, the learned single judge, my lord, has noticed that there is an alternative remedy. Nevertheless, my lords, the impugned order, my lords, the very same impugned order, my lords, is considered on merits, my lords, and it is dismissed. Lords, my only request is, my lords, delay, my lords, I may be entitled, my lords, for section 14 of the Limitation Act. Otherwise, my lords. My lords, page 2, my lords, of the judgment, my lords, the prayer 2, my lords, pertains to the very same impugned order.
Yes, 29/1/2000.
Yes, my lords, and if you lords were to see page 10, my lords, that 12. My lords, this order dated 12/5/2000, this order dated 29/1/2015, my lords, is the order. My lords, the learned single judge has held that, my lords, the case is not made out, my lords, to interfere with that order. My lords, essentially, my lords, on merits, my lords, is dismissed in spite, my lords, of there being an alternate remedy. Now, if the learned single judge, my lords, were to have said that as there is an alternate remedy, my lords, the validity of that order, my lords, will not be gone into in this writ petition, probably this appeal would lie.
If these have not made out a case as to interfere, so also. Close it, yes.
My lords, all that I would request is, my lords, delay may kindly be condoned and appeal made
Yes,
suitable lords.
but the learned counsel appearing on either side. In view of the submissions made in the affidavit, in view of the evidence in the affidavit filed in support of the application. For continuation of delay of 1477 days in filing the appeal. IA 2 of 2021 is allowed. The delay in filing the appeal shall stand condoned. In the MFA, heard the learned counsel appearing on either side. The learned counsel for the appellant fairly submits that the order appealed against had already been submitted to, had already been subjected to a challenge in writ petition number 10162 of 2015. He said writ petition had been disposed of by judgment dated 24/11/2020. Though it was found by the learned single judge that the petitioner had an alternate remedy as against the impugned order dated 29/1/2015. The matter was considered on merits and it was found that the writ petitioners have not made out a case to interfere with the orders at annexure F and G dated 12/5/2004 and 29/1/2015 respectively. Full stop. In the above view of the matter and having considered the contentions advanced, we are of the opinion that nothing survives for consideration of the appeal. The appeal fails, the same is accordingly closed. Even further, there is a chance of settlement.
My lords, with regard to the penal interest, my lords, he has not availed OTS. My lords, if they were to reject, my lords, again, probably, my lords, he'll have a cause of action. If it is permissible in law, my lords, he'll work it out.
Yes.
Obliged.
All other contentions are left over.
Deeply obliged.
One. Yes, Sudhir.
Present respondent number 3, my lords.
For the appellant, my lord, kindly trace time for weeks.
Seven, 5, 3 days delay.
Yes, my lord.
Senior is unwell, my lord. Can we have it on next week?
No, I have no objection. He was here. I have no objection.
Yes, the learned counsel for the appellant seeks a short accommodation. List on, when do you want it?
Next week.
Not next week, my lord. Let me file the synopsis. So 4 weeks time may be granted.
First
Let
week
it
of
come
April.
on.
First week of April.
Yes.
Any date, my lord?
17.
7.
Great.
Published.
13. Sudhakar B.
Yes.
Now, this is the
On
case, my lord,
369 days.
that may be condoned, my lord. And also, my lord, this is the case, my lord, Upper Tunga project, my lord, where this honorable court has held, my lord, we are challenging the order passed by the reference court, where the reference court has enhanced from 37,000 to 10,80,000. Muttina Koppa, my lord, this honorable court has already held in one of the case that 10,80,000 is correct. So. Delay may be condoned as for this.
Interfered with also. Condone the delay. Notices served on claimant, notices served on.
Notice is served, my lord, but no one has represented. It is the same village, my lord. Notification of the same year, not on the same day, but it is of the same.
Notice of the appeal is also gone. It is gone. Rebecca, do this. Will you pass orders on this?
Yes, yes.
And we condone the delay.
Yes, yes,
We'll take it from this. Yes. Heard the learned counsel appearing for the appellant, accepting the cost shown, the delay of 1369
one
days in filing the appeal shall stand condoned. Yes.
Make one submission.
Yes.
My name will not be recorded for this, telling that I have given this, the judgment on, based on this judgment, it may be disclosed.
Okay. Yes. Date need not be there. There. Yes. No, not dismiss, it is. This.
Dismissed. ma'am.
Dismiss.
Dismiss.
In that case also it is dismissed.
Yes, yes. Same order. Dismiss.
Same order,
Yes,
same
yes.
order.
Dismiss. Reason follows. Dismiss.
Is
14. SV Prakash.
1 week time may be going to file the objection to the condonation.
71 days.
1,000.
1,000.
Oh, this is item 15, sorry. 14.
14.
Next week,
Weeks.
27th,
my lord.
Two.
27th, not
Next
next week.
AGA. For re-notify so and so. In the meantime, learn AG is permitted to file objections if any to IA1 na? IA1 of 21.
15 urgent. 16. Kavita Damodaran.
For the petitioners, my lords, there is a delay of 71 days, my lords.
Allow it
We condone.
please.
Yes. In,
Same order.
yes.
Accepting the cost shown in the.
My lords, the interim order in this matter may be extended.
21. The delay of so and so days is condoned.
3 of 25.
IA,
21. Yeah, 3 of 25.
sorry, IA 3 of 25.
71 days.
71 days, madam. 71 days. Is here by condone. But in records ಬೇಕಾ ಇದೆಯಾ ಬಂದಿದೆ madam?
Admission.
Heard admit. Heard admit. This is appeal for hearing.
Yes, my lords, the interim order may be extended.
Yes. Interim
date may be
granted
fixed.
earlier stands extended.
Records for that.
85B. So the only matter pertains to the 85B. But it's a civil obligation, but it's a cover judgment. So,
Second week, go down.
8th.
8/4.
Much obliged.
17 urgent. 18. CB Anaya.
Weeks time. Weeks time. Objection complaint. Weeks time granted. Comply the office.
19. Bhargavji.
Your lordship.
R4.
There two office objections and one is R4.
we have filed an IA for affection of C. And in that objection was, we have not, second was, paper book was not served to the opposite.
We have received it.
They've received it. And there's one small objection on paper book, that signature of the advocate is not forthcoming, might be overruled.
What about R4, substitute service, huh?
Substitute service is done, but we have
IA is
filed
there.
an IA. It may be posted for hearing on IA.
Final hearing, it may be posted, my lord, is the subsequent purchase.
The IA has to be.
Moreover, R4 was not represented in the lower court as well. It was the next part.
Objection, madam, wrong complaints of parties, objection on IA.
For R4. Okay, so then, IA has to be ordered.
R4 is not served.
Not served now,
Not-
you have to take out notice.
We have filed an IA for allowing the affixure of the notice, Your Lordship.
Fixture.
Yes.
In the
Because even in the lower court, they were ex parte, Your Lordship. They were not represented.
By way of substitute service, tagoli, notice to R4,
Let them correct paper publication.
paper publication.
Oh, yes.
Permitted, then counsel for the appellate is permitted to record the take steps, necessary steps to serve
sure.
notice to respond number 4. Way
Finally,
of substitute service, way of substitute service.
second office objection may be over. Paper book agi.
Yes, that's okay.
For fine,
Counsel submission. Office, it's on paper book.
paper book has, we have received it. Final hearing,
Paper book.
final hearing.
Final hearing, service ಆಗಲಿ, service ಆಗ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, ಅವ್ರು ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ. They have not appeared before the lower court
Lower
also.
court also, they were unrepresented.
File a memo for dispensing of service to R4. Then file a memo for dispensing of service to R4.
Okay.
We can allow that
Ah.
instead of
Based-
filing IA, all you have to do is file a memo.
Please.
We'll allow it at your risk.
Please, Your Lordship.
Now itself, file a memo.
Please.
Yes, and counsel for other, take the bid, and counsel for the appellate files a memo. Huh?
Files that you take the data.
Mm.
Bid, huh?
Doesn't-
Fine. Barbara. Right. So we're next week, huh?
That's
Date other-
expected.
Yes.
Yes.
Date,
Next week, please file it in the meanwhile. We'll
yes.
order it at your risk and then list it for
Finally.
hearing.
Much.
20, Jaiprakash, RV.
There is a connected appeal filed by respondents 1 and 2 in RFA 1680 of 2015. Already here, the notice sent is returned unclaimed. Therefore, notice may be held sufficient and it may be posted along with the connected appeal.
Who is appearing in that appeal connected?
In that appeal, I appear for the respondents, the advocate. There, in that appeal, Mr. Shivram Bhattu appears for the appellants.
We'll list both of them
Yes.
together. If he's taking notice, we can.
Yes, yes. List this appeal along with the
RFA number
RFA number
1680
1680 of
2015.
2050. Yes, yes. We'll see thereafter on that day.
Aye.
Mm. 21 adjourned, 22.
Next time,
Yes.
2 weeks. 2 weeks time granted.
23.
For the respondent. Appellant has to take.
Paper book.
Paper book.
On file,
Hmm.
same 2 weeks.
2 weeks.
2 weeks.
Much okay.
24, KK Vasant.
Hearing for respondent.
I
number two in
appeal
this
for the
matter.
appellant.
Appeal for 3 and 4 in this matter.
Lord, what has happened? This is notice was ordered on 9/11/2017. And all the respond 1 to 4 are on record, they're represented by their counsel. So for respondent 5 is considered a tenant, he is served unrepresented. Now, some of the lawyers have filed the memo for retirement.
R1 and R2.
Yeah, R1 and 2, there are 3
I appear
advocates.
for R3 and R4, my lords. I filed
appear
NOC Wakalat on 22nd February. My name has to be reflected, my lords.
Respondent number 2, I appear. My name is reflected, my lords. Sridhar for respondent number 2.
Then
R3 and 4 I
counsel
filed NOC Wakalat.
for filed memo of retirement for respond number 1 and 2. However, the learned counsel
N. Sridhar
N. Sridhar
appearing for respondent number 2 has already filed.
submitted he filed power 2,
Please,
respond
ma'am.
number 2. Office is directed to show the name of she so and so for respond number 2.
That again, PK Manjunath for respondent 1 and 2. That's also there.
Memo accepted, estimate. Memo accepted and office directed to delete the name of she so and so so and so. Prasanna Kumar, idhar our name torista idara? Illa. Prasanna Kumar,
Lord, that may be said that notice not yet ordered, my lord, so far respondent 3 and 4 is concerned. It was ordered long back.
Respondent
And
number
they
3 and
have-
4 I filed NOC Wakalat, my lords.
he filed wakalat.
They have represented it, but
My
office is showing the note. That note is not yet ordered. So far respondent 3 and 4.
No such notings, office notings in it.
Notice ordered in the year 2017 itself. That may be removed, my lord. And they have sought for the early hearing of this appeal.
Since respondent number 3 and 4 represented to the council, Mr. So and so, office is directed to the, how to delete the bad one, make available. Show the name of she so and so so and so.
Yes, please.
IA 1/22 is being filed by the respondent number 1 and 2, my lords. Early hearing matter. It's a suit for partition. Wherein
Yes,
the
I
father has,
I filed the paper book also.
a date might be fixed for final hearing. my lords.
Yes. This appeal for hearing on so and so. Accordingly, IA 1 of 22 is disposed.
Please,
Yes.
date might be fixed.
Date kodi madam.
Respondent number
R3 is a senior citizen, my lord. She's in a deathbed. She may be permitted.
8th April.
8th April.
8th April. Obliged.
Obliged, my lord.
8th.
Matter might be posted for final hearing, my lords.
Hearing.
Please, obliged.
Straight from my lords.
25, B Pramod.
The BDA was supposed to file an affidavit. This is that alternate land issue, alternate that you collect.
R9,
R9. They did not furnish the details of legal aid. We sought for the details of legal aid from the respondent. They did not furnish because it is likely to be.
No, I
disposed of.
think on the last date we made. No. I think on the last date we made a submission that R9
Not
was
required?
seized, but may not be necessary is what I think we have submitted, but I'll just get instructions on that point. But in the meantime, anyway, I think BDA may have to file that affidavit as directed by your lordships. I'll also get instructions on that.
this is that,
Furnish the name. The only that we can said not necessary. Why should I?
Help me here.
this is that alternate site.
Yes, ma'am. Where we had
Account of
challenged,
the acquisition being,
correct, ma'am. Where we had challenged the acquisition and now the BDA has filed a review petition in the Supreme Court after this petition was filed. They were the allottees while the acquisition proceedings were under challenge.
No. We are the allottees prior to the
Prior
acquisition.
to-
Were challenged. We are not made parties before this single bench.
where is the BDA?
Your lordship, I am for the BDA, your
Hmm.
lordship. Your lordship, kindly give us a 2-week time, your lordship. We will file our affidavit, your lordship. The original file is missing.
Learned counsel appearing for the BDA seeks 2 weeks further time. What about R9? Is it, if it is not required, then
I'll take the details from them.
please stop
Interim
it
order to be
2 weeks.
extended.
Interim order shall remain in force.
Grateful.
Please.
26,
Lord, in serial number 26 bar 1, Lord, I appear for the appellant. Lord.
not even on the last date of hearing, not requested, not that the office objection has not been removed by the other side. To see that the appeal is disposed of, or early, I have even filed paperbook. It is a case, where the connected appeal is filed for enhancement, and the first appeal, is being filed to reduce the compensation. They have not paid the court fee. That is one of the office objection that has been raised.
What was the appellant?
I say last chance.
2726 of 2020.
Please, Millards, I'm sorry, Millards, my
Have you complied?
colleague had, Millards, I have paid more court fee, please, Millards, than what has been required. Now, the office raises some certain objection, Millards, I'll go and explain it to the office. But what was required, Millards, I paid more court fee actually. It is not.
I'm counsel for the appellant in MFA 2726 of 2020 submits that office objection has been already complied.
Yes, Millards, I have paid more court fee than what is required.
If that be so,
Because there was
then
some urgency, please, Millards, I have to come this side and for the appellant.
If that be so,
I'm
then
sorry, my
counsel
lords.
is Directed to clarify the same in the registry. Yes.
Millards, 1 week, Millards, there is some urgency. Next week it can be taken up.
Yes.
Release.
Or some date may be fixed.
Yes.
So very grateful, please.
21.
Lacy, claimants appeal third time.
Pradeep Casey.
Paper for appellant, madam.
Hmm.
Kindly notice may be issued, madam. I'm seeking for enhancement of.
What about the
With respect to
of
objections,
objections?
please, madam, I have made a court fee good, madam.
Hmm.
Please.
What else? There appear to be
Respect to
other.
one more objections is concerned, madam, they have sought for reference order. That is not necessary, madam. With respect to the same notification, madam, already.
Still are office objections with regard to your court fee. Please.
Sufficient court fees paid, madam, with respect to same, madam. 1,58,000 already paid.
Please verify
Please, madam, I will verify.
Weeks time granted.
week's time. Yes.
28.
My lord, in this, the office objection has been raised in respect of my valuation slip.
Yes.
I'll do it in the course of the day, my lord. I've paid my court fees. There appears to be some discrepancy. I will make that correction. Connected matters of this, in respect of the same award are posted on 28th of this month.
The learned counsel for the appellant submits that the court fee will be made good during the course of the day. List along with connected cases on 20.
Grateful.
Please give the numbers.
Yes.
29. Srinivasan MY.
There's no representation. Finally, a week's time granted.
In this case, madam, HGP already represents respondent number 1 to 4.
Madam, take the video.
Respondent number 1 to 4 already represented by HGP. So notice not necessary, and cost already paid.
Yes. Appellant submitted cost already paid. Cost imposed by this already paid. The further respond number 1 to 4.
1 to 4, yes.
1 to 4 represented by the learned counsel for AGA.
Copy ಕೊಟ್ಟಿದೆ, sign ಹಾಕಿದೆ. ಇದೆ.
AGA, answer.
ಇಲ್ಲ, canal ಇಲ್ಲ.
It's connected case.
Further notice is answer. Office objection. Permission of. First type, 1 to 4.
In another case, executive engineer.
R1.
Huh?
You are not appearing for R1, madam.
Who's that?
Executive engineer KRS.
ಅಪಿಯರ್ ಆಗಿ ಮುಗಿದಿದೆ. ಗೌರ್ಮೆಂಟ್ CGP ಆಲ್ರೆಡಿ ಇನ್ನೊಂದು ಕೇಸ್ ನಲ್ಲಿ
ನೋಡ್ತೀವಿ, I will verify. Because I can't appear. R1 is telling me in another matter SGGP has taken notice. Okay, verify.
ಏನ್ ಮಾಡೋದು ಮತ್ತೆ?
ನೀವು ಸೈನ್ ತಗೊಂಡು
R1 ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರಾ?
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ. ಗೋಪನ್ BPDS associates.
Says government will take, so a week's time election.
Associates.
I, the week's time granted. To comply the office objection, ನೋಡಿ ಯಾರ್ಯಾರು ಇದ್ದಾರಂತ.
ಅಲ್ಲ, R1 ಗೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಫಸ್ಟ್ ಬೋಪಣ್ಣ ಇಸ್ ಬೋಪಣ್ಣ
Last ಯಾವಾಗ ಪೇ ಮಾಡಿದ್ದೀರಾ ಸರ್?
ಕಾಸ್ಟ್ 10th June 2024 I have paid the cost.
9125 not paid ಅಂತಿದ್ದಾರೆ.
ಇಲ್ಲ ಎಲ್ಲೈತೆ
ಎಷ್ಟು 2000?
2000 ಇಲ್ಲಿ ಫಸ್ಟ್ ಮಾಡೋದು ಮತ್ತೆ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ
12,6
It's paid.
paid.
Memo ಹಾಕೊಳ್ಳಿ madam. Counsel for the appellate files a memo stating that the cost imposed by this
Paid.
court has already been paid. Next. The
1 to 4 malad is a HGP malad in another cases malad. Already 5 cases settled malad is a HGP take notice in another cases. That's why malad the notice is not sufficient. The next time ನೀವು ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಒಂದು notice ತಗೋತೀರಾ.
to take steps ಅಂತ 1 week time ಕೊಟ್ಟಿರ್ತೀವಿ, ನೀವು ವೆರಿಫೈ ಮಾಡಿ.
ಅಲ್ಲ 2 to 4 ಬೇಕಾಗಿಲ್ಲ. ಒಂದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ಗೆ BPDS ಅಸೋಸಿಯೇಟ್ಸ್ ಇದ್ದಾರೆ. ಬೋಪಣ್ಣ I will take notice to Bhopal.
Learned AGA is directed to as a notice to respond number 224. 224. To take steps
Respond number 1 malad I will
respond number 1.
standing counsel malad ಬೋಪಣ್ಣ is there.
Issue notice ಮಾಡ್ತೀವಿ ಆಯ್ತು. Let fresh notice issue to respond number 1. Please. Yes.
30 Srikanth KS.
During the course of the.
Finally, 1 week time granted for compliance on 16/3/23. Failing which the appeal shall stand dismissed. So after 1 week from 16/3/23, the appeal
That
is
is the
dismissed.
file has been misplaced, my lord, that's why. Today only I will complain.
No further order is required. The order. Deliver it.
Now you can pay, then
63/2023. No further order is required. Will stand dismissed. Happily application.
Yes.
32 Naik and
My lord, R2 and R3, my learned friend is appearing for PDF, my lord. I have served the copy also. Acknowledgement has been filed. My lord, they may kindly be permitted to serve, shown in the cast title.
Respond number
31 serial number.
DA.
31.
PD.
PDS, K. Krishna is there.
I will take
Counsel
notice.
K. Krishna is directed to accept notice
R2
to
and
respond
3.
number 2
2 and 3.
2 and 3.
Both 2 and 3.
There is a delay in 16 days, my lord.
Hmm?
It may be condoned.
16 days in file.
Yes.
16.
They are accepting the cost shown in the affidavit accompanying to IA number
IA number
2 of
2 of
2023.
23. The delay of so and so days is hereby condoned. According to IA 2 of 23 is allowed. Next ಏನಿದೆ?
Any short date, my lord, because
Admission.
admission. For admission,
weeks.
my lord.
ಆಯ್ತು. ಹಾಕಿ madam, ಯಾವಾಗ? We'll notify second week. Third day.
9/4
Please.
2
Great.
Much of.
I beg to appear for appellant, my lord. In this case, my lord, only the time was sought for extension, my lord, for 2 months has been granted to get it registered, the association, as per the Act of Appointment Act 1972, my lord. Now I am going to withdraw, my lord. Kindly may permit me to withdraw the writ petition, my lord. Already got it registered, my lord.
No memo filed. Last time also we had requested you to place a memo on record, counsel.
Yes.
Why is it not on record?
Please, my lord, because I have not filed, my lord.
Please file it, counsel.
Today, 2:30, kindly may call me. I will
Tomorrow.
file, my lord.
Please place it on record. We'll order it on the next date. Monday.
Please, my lord.
Monday. Please place it on record today itself.
Please, my lord, please.
33
Eighth time.
Translation.
LAC translation.
Regarding factor as stated in the
He is not interested to prosecute.
Mm, mm.
Yes. The though this court has granted sufficient time to comply the office objection, and today the matter is listed for 8th time for compliance of office objection, there is no representation for the appellant. Hence, it could be gathered that the counsel for the appellant not interested to pursue the appeal. Accordingly, appeal dismissed for non-prosecution.
34, submitters.
Lord, subject to my lord's convenience, may I pray for 2:30, please, my lord. I deeply apologize for the inconvenience, my lord. 2:30 may I pray for, my lord.
2:30 today, I have some difficulty, my lords.
Let's have this on some other day because there is a different combination at 2:30.
Please,
So
my lord.
2:30 today may not be possible.
Please, my lord.
Let's
Please,
have
my
it
lord.
on some other day,
Wednesday, my lords.
But,
some date next week.
but 27th, my lord. 27th, my lord.
My lords, my only difficulty is this: almost 6 years has lapsed since that attachment originally took place, my lords. The IO himself, without jurisdiction, attached my property. Thereafter, my lords, the competent authority also, in violation of the act, has gone for a confirmatory order, my lords.
Let's see. Yes, list it, please.
I have paid the entire amount, principal amount due, my lords. Principal amount that
It's
was
only
due.
with regard to the interest.
With regard to the interest, my lords, I'll even furnish an indemnity bond to that effect. It is about 30 lakhs as on 31st March this year. Therefore, my lords, if I may be able to deal with the property at least, my lords, that is my limited prayer at least for the purpose of this application.
Lord, I understand the difficulty of my learned brother, my lord. But remember, taken up on 26th or 27th, the matter itself may be disposed of. Now that, my lord, sits in a very narrow realm of law, my lord.
Very well, my lords.
List on 27.
Please, deeply obliged.
Yes.
27th. I'm grateful, my lords.
Blessed.
Both at 2:30. Okay. Then let's call the final hearing. Anybody, both sides are ready, minimize.
Final hearing, 35, H.V. Subramanian.
I pray for respondent.
Specific performance.
Yes, so I may be permitted to appear for the appellant.
Is it likely to take a long time? Or is it
Madam,
specific performance? Is it likely to take a long time?
performance. That's the difficulty, immediate difficulty is that the entire evidence and entire judgment is in Kannada.
In a
Therefore, I
first
thought
appeal,
I would
in a
publish
first appeal, we can't
that given some
not do
reasonable,
away with the translations.
given some reasonable time, I would furnish the translation itself. In fact, yesterday they gave me the paper book. I have been literally burning the midnight oil.
First appeal, we can't hear it without translations.
Required translation.
If it were a writ appeal or something, we could have tried to manage with, but the first appeal and the judgment being in Kannada, we cannot go forward. We can do two things. It's a 2013 matter. We can
13.
either give you a posting, maybe, or we can try listing it after vacation. If there's a change in the roster, this
No, my
difficulty of
lordship,
having to translate may be done away with.
Let them furnish this translated copy.
Then why I said I
Because
I say-
already 2013 matter.
We can list it after the holidays and see whether there is a change in the roster so that.
My lordship, my party is 75 years aged, my lordship.
Even otherwise.
Entire his retirement fund has been invested on this property, my lordship.
16.
The suit is of at 2011.
For filing paperwork, 4 weeks time is seeks. ಅಷ್ಟೊತ್ತಿಗೆ vacation ಬರುತ್ತೆ ನೋಡೋಣ vacation after vacation ಆಗುತ್ತೆ.
One date fix ಮಾಡ್ಬಿಟ್ರೆ let them furnish ಯಾಕಂದ್ರೆ ಯಾವ ಬೆಂಚ್ ಮುಂದೆ ಬಂದ್ರು one date fix ಮಾಡ್ಬಿಟ್ಟು let them produce the translated copy. Later it should not be.
Not, the judgment is a very short judgment. That may not be too much of a problem.
Yes, ma'am.
But if all the documents are in Kannada, then
Documents are also in Kannada. In fact, the material contradictions in the evidence of the witnesses, that mirrors the effect of that mirrors. If translation
Let
is
them
there,
produce the
it would be
translation.
convenient for me to persuade the court because
Do one thing.
16
can we
lakhs, they
discuss
say they have.
immediately on reopening? In the meanwhile, if you have.
Immediately after
produced-
reopening, it may be posted. Because this
Fourth
translation takes some good time.
4th June,
Yes.
36, Abhinavar,
My lordship, a direction may kindly be, my lordship, noted.
The learned counsel for the appellant submits that the judgment as well as the entire pleadings and documents are
There
in,
was an interim order, it may be.
Kannada. And that a short accommodation may be granted to submit the translated copies. List on 4/6/25. In the meanwhile, translations shall be provided of the relevant, translation shall be provided by the learned counsel for the appellant. Interim order, if any, shall stand extended till the next date of hearing.
36, Abhinavar,
Fifth respondent. Also. 230 euro.
Declaration. Only decrease there.
Decrease.
Certified copy, type copy, 70. Also valuations here.
Valuation.
Judgment copy is marked, but no copy, only decrease there.
Decree ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. ಇವ್ರು ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಮಾಡಿಲ್ಲ.
3287 will,
Yes, you.
that would settle it. You are for?
Fifth respondent, you are. Fifth respondent, purchaser. Can you pass over the
Purchase.
matter also? It is considered up in other code.
So what today, no point. We have, there is a separate combination after lunch, after which we've already passed over.
Next
some
week, any
matters.
date?
Make-
Next
cannot-
week, next week, any date, maybe.
3rd April.
Hmm.
Earlier, to third, next week, third, next, earlier.
Shortest.
Short date.
3-7 shortest, 3-4 shortest.
Yes.
37, Jain Devkumar.
Senior is on his legs in a parted matter, my lords. Kindly, a short accommodation may kindly be granted, my lords.
Respond, please.
Date may be.
3-4.
Obliged.
Second week of April. my lord. 3-4, there's a personal inconvenience.
Second week,
Second week,
later put it.
7-4.
please.
38.
I am here for the defendant respondent number 6, my lord. Great time, my lord, my senior in out of station.
How many are there? No, Giri.
This is WP.
My lord, for the petitioner, my lord, on dated 1/3/2023, the coordinate bench has passed us some odd detailed order, my lord. With respect to the, my lord, AG has to, my lord, make specific stand regarding the, my lord, whether property is belong from the government or it is belong from Masjid. The, my lord, land in question, my lord, the subject matter of the land in question, it is originally belong from the, my lord, municipal council of the, my lord, Kunigal of Tumkur Taluk. And, my lord, the property was stand in the name of the 6th respondent office itself. Later, my lord, the respondent private
Just
Masjid, sorry.
just a minute.
This has not been placed on record.
No.
Instruct- Additional advocate, advocate general for respondent number 1 to 5 is directed to ascertain whether the land measuring 2.16 acres situated in survey number 95 of Kasba Hobli, Kunigal Taluk is a government land. So reference in this petition to proceed further. Therefore, a report has to be made available.
The property is more than 600 crore.
Hmm.
Earlier, it was stand in the name of the municipal authority.
Hmm.
That is, my lord, 6th respondent.
Hmm.
Even till today, my lord, the revenue record stand in the name of the municipality.
No.
But based on the political motive, my lord, it was permitted orally, you can construct. Accordingly, your lordship may kindly peruse, my lord, one important document, that is photograph, that is running page number 111. Wherein, my lord, this is the how the sheet has, my lord, fixed. And, my lord, inside 180 complex shutter has been developed for the commercial complex for somebody's earning. That is 5th respondents. Wherein, my lord, this has happened.
So the question is only this.
Yes,
Whether it has been legally handed over to the, as an Idga or not. If it is acquired and handed over, that would be the
Yes,
end of
ma'am.
the matter.
Before that, my lord.
Hmm.
Earlier, my lord, when it is posted before this honorable court,
Hmm.
dated, my lord,
21-1 to 2020, before Lordship Justice Arvind Kumar and Indresh, the specific stand has been taken by the, my lord, state government, saying that it is belong from the state government itself. And based on that, my lord, I have secured all necessary document which has been submitted by the, my lord, authorities between themselves. Then, my lord, I have placed before this honorable court. And after that, my lord, Lordship Justice Alok Arade and my lord Vishwesh Shetty, dated 29-10-2021, directed, my lord, application shall be considered at the time of hearing in the petition. So that, my lord, all, my lord, the document which I am relaying now, which is additional document, my lord, after so many development has been taken place, then, my lord, it is proved and DC has said that this is belong from government land. Therefore, my lord, this honorable court by order dated 1/3/2023, please take specific stand and expected from the AG office. What is your stand? Based on the government documents. All government documents, my lord,
It has already been recorded that no construction is being carried out in the property.
property, but it is now stopped, my lord.
Yes.
It is stopped.
Your lordship, two interim applications seeking stalling of the construction were dismissed by this honorable court.
No.
Yes, I'll produce those.
There
I
is-
have it with me.
There is a finding to, I mean, there is a recording of a submission that further construction activity.
Your lordship may kindly
As on
see
that
the-
day, your lordship, as on that day, we were not constructing. Your lordship, by this honorable court by order dated 3/7/2018, dismissed his application seeking stay over construction. Once, 3/7/2018.
My lord, 21.
Just a moment,
Sorry.
3/7/2018.
Yes.
Hmm.
What's the last in that order? In that order, your
I
lordship,
mean, how do you come into possession of the property?
through a gazette notification done by the then Mysore government in 1963, and my name is there in RTC, and I've been paying taxes, I've taken building license, and gazette notification is also part of the record I produced in the statement of objection. There is a report from the Tahsildar, which is respondent herein also, which says that the land belongs to me. The matter first went before special land grabbing court, and that
Special
court
court
also,
also says that.
it belongs to me after perusing the document that I submitted.
My lord,
And your lordship, I
That
may
report
be,
has to be placed on record.
my lord,
all the documents
What
are in.
time? You'll do it within a week. Yes,
All the
Learned-
documents are in Kannada. I'll translate it and produce it before your lordships.
Learned AG
my lord, one
seeks a
submission,
short accommodation
one sub,
to comply with the order dated 1/3/2020 and to place the report on record. List after 2 weeks. Please do the needful in the timely.
one submission, my lord,
Yes.
if permitted. My lord, dated 21/1/2020. This honorable court has made a specific observation after your lordship has read that order.
There is also an observation that any,
Entire
Uh,
construction activity must be stopped. That is, my lord, dated Justice Arvind Kumar and E.S. Indresh has passed the order. Dated 21/1/2020.
there'll be an interim order of stay as
Yes.
prayed for, directing respondents not to alienate the disputed property, not to form any layout, not to convert and not to put up any constructions on the disputed property in question.
That was
pending
recalled.
steps.
That interim order was recalled, your lordship.
Yes.
Then, my
That
lord,
interim order was recalled because after suffering an order, he filed
Then-
another
then-
application seeking
Just
the
a
same.
moment, just a moment. Yes, then there is. inter alia.
21/1/2020 order.
7/1/2019, that interim order is recalled.
21/1,
7/1/2019, your lordship.
this I will complete.
Just said, objection
21/1/2020.
Any shall be filed, so and so, this is this matter.
21/1/2020 order.
To file a report with regard to the order in question. In the meanwhile, it is made clear that construction activity being carried out by the seventh respondent would be subject to result of the present writ
Yes.
petition, and the seventh respondent would not be entitled to claim any
Equity.
equities whatsoever.
Yes.
That is on 8/1/2020.
20. ಆಮೇಲೆ 21/1/2020 your lordship may kindly peruse.
Hmm.
21/1.
Hmm.
I'm sorry, my lord, I'm troubling you, Honor Lordship.
Hmm.
Learned Counsel for the Advocates has filed the memo of enclosing report of the fourth respondent. Same is placed on record on instruction of Shivkumar CL, Assistant Commissioner Tumkur, Subdivision Tumkur, who has present before the court learned AGA submits that construction activity of the immovable property described in the schedule to the interim prayer of the writ petition has been stopped. His submission is placed on record. Learned counsel appearing on the seventh respondent submits that is my friend, my lord. The statement of the objection has been filed. However, the learned counsel appearing for the petitioner submits that he has not received the copy, hence relisted on so and so.
It's a mere recording that at that moment there was
So
no
that, my lord,
construction. There are two positive orders
Hearing
from
only
this
for
court.
the, my lord, one particular, my lord, individual. But my lord, Waqf board also, my lord, made as a party before this honorable court after the direction. And my lord, our first title has been amended.
I'm the
He is
committee-
appearing only for the Masjid.
I'm the committee under the
institution.
Waqf board and I have the possession of the
Yes,
property.
please,
To the result of this.
Yes,
please, place it on record.
Very well.
my lord, last 1 year, my lord, state has not did so, my lord.
Yes, it's done.
$39.
This matter is with respect to that overcharges.
Yes.
Been argued, my lord. Again, my learned friend will not come, my lord. Let him come, my lord. I'll argue the matter. It's already argued, my lord. Then again,
Ingestion charges.
congestion charges, my lord. 106 of the annihilation.
It is between the KIOCL and the union.
Both the
Railways.
railways.
Taking by one hand and giving it to the other. Yes. Sorry? What does it say?
Our advocate ಮಧ್ಯಾಹ್ನ ಬರ್ತಾರಂತೆ. ಇದು afternoon.
Good afternoon. We have a different combination for a while
Please.
and then two passed over matters. Is it- Give him a specific date and ask the party to get the lawyer in the morning next time it is posted. Yes. Private siding.
Private siding, my lord. Panambur private siding. In the meanwhile, I'll also I have the synopsis, my lord. I'll file it. The reason for this is, my lord, your lordship had posed me a question that within 3 years which are there, that I have it, my lord. In the meanwhile, I'll file it, my lord. I'll also file it. But my lord, let that be that he is not come, my lord. I am not seeking time, but
Yes.
because the order sheet, the officers are there, my lord.
The learned counsel appearing for the respondent. KIOCL is not
Right.
available today.
Friday,
List the matter for final hearing on, give a date, please.
please.
We have recorded that the learned DSGI appearing for the appellant in the MFA is ready for arguments. However, the learned counsel. Yes.
40.
Paper, the appear of appellant counsel. Today is interviews of the appellant counsel. That next week.
Let's see what is
That is a PNDC as dismissed by the lower court.
Why? Why is it dismissed?
That LRC is not brought on record on Friday.
What can be that?
Next week I will do. The council is in interviews today. Council MB Chandrachуда is interviews today. Next week, any date, Millard.
Only to be allowed. Sole legatee. Only ground on which it is dismissed is that he is not the executor of the will. Sole legatee is the implied executor. Can I have the Succession Act, please? Intention of the trial court is that only the sole only an executor can seek an application for probate. But it is the provision itself says either express or implied. If there is nobody appointed as executor and there is only one legatee, this is covered in your
And-
favor.
Presence of the appellant counsel, Monday. Monday itself is, today is done to hospital, very. We take appointment of the doctors, my lord, today. Monday,
Covered is the name of your.
that is, in the presence of the appellant counsel, Marposala, I do it. Nothing, Monday will take. No, no.
Probate only to appointed executor. Section 222. Section itself says by which shall be granted only to an executor appointed by will. Appointment may be expressed or by necessary implication. Therefore, if it is a sole legatee, by necessary implication is also the executor. This is sole legatee. Sole legatee of the will. Legally, there, but notice has been taken up that the publication of the appeal. Why did you not make the legal aid also
Monday,
parties?
in the presence of the appellant counsel, my lord, it's not in the, it up. Monday.
You are not the arguing counsel.
I am not counsel, my lord.
Arguing counsel
Yeah,
is
Hospital over there, he taken.
arguing counsel.
He take appointments of the doctors presence.
Notify our.
Date.
2nd April. 41.
This is a short matter. Yes.
Vacant is a bank.
The short question is not there. The bank has not issued a secured loan of sum of rupees 35 lakh rupees to the respondents. But after the sum of rupees 17 lakhs rupees has been released. Thereafter, it came to the knowledge of the bank that the respondent, without the knowledge of the bank, has sold some portion of the property which has been hypothecated, stopped the further issuance of payment and filed a dispute under 70 to realize the amount. But 17 lakh plus interest, sum of 22 lakh rupees, proceedings has been initiated. The Register of Cooperative Society directed to remit the amount. That order has been challenged before the KA team. The KA team, the subject to the deposit of 50%, interim order has been issued. The respondent did not deposit the condition imposed. Preferred a writ petition against the set order. But that writ petition has been dismissed, confirming the order of the KAT, interim order passed by the KAT. Against which again the review has been filed. That is also dismissed. A writ appeal has been filed. During the pendency of the writ appeal, during this period, since the interim order has been not complied, the bank proceeded with the sale of the property. Auction has been conducted. Property has been sold to some third person by the bank. Meanwhile, when the writ appeal was pending before this honorable court, the intervening application is filed before the in a writ appeal, giving the offer which has been more than what the bank has sold. In the writ appeal, this honorable court set aside the sale done by the bank.
The bank was a party to all the proceedings.
All the proceedings.
Right?
Yes, ma'am.
Shall we read paragraph 14 and 15 of the judgment?
Yes, ma'am.
Page 30 and 31. Writ appeal number 580 of 2007 was disposed of on 12/11/2007.
Yes, Lord. Now I'm coming to that point only, madam. Brief facts I'm narrating what had happened.
After, you
Thereafter-
also filed a review petition.
Yeah, I have filed a review petition, but
Nowhere you have a case.
no, I'm not, I'm only stating the facts, Lord.
Yes.
So, Lord, during the pendency of the writ appeal, a purchaser had come, Lord, giving a more offer, Lord, a better offer. Then, Lord, the bank, which is the sale done by the bank, has been set aside. Lord, it is directed to register them, Lord, sale deed in favor of them, Lord, the purchaser. That has been done by the bank. However, Lord, that order has been, we file a review. Review will set aside. Specially petition filed before, Lord, the Supreme Court. Lord, that has been withdrawn. The sale has been done. I'm not questioning that, Lord, anything, the sale.
Nowhere in any of these proceedings did you raise a contention that you had paid this amount and that also has to be
Yes.
factored in. There is a direction in writ appeal 580 with regard to payment of amounts to the original owner,
That is, Lord,
whatever that be. You did not raise this in those proceedings at all.
yeah, I have
How
not
can-
raised.
How can you raise it in a separate proceedings when it was part of the initial, you were a party all along.
I'm a party, this
Did you
proceedings.
not raise it? If
The-
it is in respect of the very same transaction, in respect
not
of the
for the-
very same property,
No, not, it is for the same property. When
therefore why did you not
no, the
raise it?
cause of
before this
action
court?
arose, Lord, in between
When?
the proceedings.
Absolutely, in between the proceedings. When did the cause of action arose? The
Lord, in the
dates-
year 2007.
Dates are mentioned by the learned single judge.
Yes, Lord.
When did you make the payments?
Lord,
according
we
to-
made the payment, Lord.
Hmm.
I've given a chart itself, Lord, my appeal memo. At page number 10. 17/4/2007, commercial tax of 2,76,942.
17/4?
17/4/2007, Lord.
17/4/2007.
Seven.
Then,
Lord, the 5 payments, Lord, the chart I've given in page number 10. Your
yes,
Lordship.
17/4. Which are the dates? Please give us the date.
17/4/2007. Then, Lord, 18/4/2007.
12/6.
12/6/7. The 2 payments and 12/6/7. 5/6/2007. So all in 2007, Lord.
Correct.
Yes.
And writ appeal was pending at the relevant time.
Due-
Appeal is
yes,
disposed of on 12/11/2007. No whisper of this amount.
yes, Lord.
No,
You
that
did not bring it to the notice of this court.
We,
Then you file a review petition. You file a review petition. The review petition is disposed of when review petition is heard. 9, 10 is under review of the one-time settlement.
16/4/2008.
16/4/2008. There also no whisper. You take up the matter in SLP. Nowhere do you have a whisper.
Lord,
What prevented you?
certainly, Lord.
This public
This-
money.
Yes, my Lord. So this, throughout the whole litigation, my Lord, up to the writ appeal, it is preferred by the, my Lord, the private person. I am the respondent in
You are
the
the
dispute.
You are
Yes, my Lord.
party before the court.
I am party proposed, my Lord. Certainly, I would have been, my Lord, made an, brought this to the knowledge of the court, my Lord. These are the additional amount we have spent it. But, my Lord, initially the dispute only raised for only recovery of the amount of which the loan is given. Lord, these transactions took place in between, Lord, when he has not complied the order, when the bank went to the auction of the property,
True.
it is came to them, Lord, the bank has cleared these amounts. But merely only, Lord, the bank has not brought to the knowledge, Lord, in earlier proceedings. So, Lord, it is not in double jeopardy, Lord, that I am not claiming, Lord, in a second round of litigation. The
Second
separate
round of
dispute I have filed.
It's a second round of litigation, very same dispute.
Dispute,
Part of the very same dispute. It is amounts. You
it is an
claim
additional amount, not
amount as part of the very same dispute.
which has been paid subsequently, Lord. The sale, the bank, Lord, the sale took place from the bank, Lord, that is being cancelled, Lord, by impleading applicant, Lord, coming in, Lord, it is in the writ appeal.
Therefore, you were a party to that dispute.
I was a
You
party
could
to
have
the writ
brought
appeal.
it to the notice of the court that I have paid so 5 lakh so and so rupees
Yes,
for towards the charges. What is this? Tax. Principal
Taxes.
tax. Therefore, that also is to be set out. You failed to do so. It is part of the very same transaction. And it cannot be raised as a separate dispute. That is all the learned single judge has said.
but my contention is that, Lord, it is not a second dispute for the same transaction. The transaction is different. Though maybe, Lord,
Claim and the cause of action.
Lord, it's
of
ultimately a
Abandonment
public money, Lord.
paid as taxes got merged with the dispute which found its finality in the order of the Honorable High Court in 518. Therefore, R1 Bank was not justified in filing a separate and fresh dispute against the appellants claiming. Yes, please tell us what is a dispute under the Cooperative Societies Act. It's a cooperative society.
Cooperative societies.
What is a dispute?
Dispute is not for a recovery of the amount which we have paid towards a.
What is a dispute under the Act, Counsel?
Not the dispute, not for recovery of, not the dues.
Cooperative societies.
70.
It is any claim by the bank as against
The member of the.
a member,
Member.
employee, whatever, any claim.
Yes.
Therefore, and if it is a person who is mortgagee, also you can raise a dispute. But it is any claim. If it is part of the same claim, it is a dispute. And if this amount is part of your claim in respect of the very same
First.
transaction, that is the end of it.
Yes.
It should have been raised as a dispute.
Yes.
And if you did not raise it, and if it is part of the same transaction, appeal judgment.
When we filed, Lord, the dispute, there was no cause of action. This amount we have not paid it. We, as far as, Lord, the loan amount which has been defaulted for 17 lakhs plus interest. So the proceedings took place from there itself, Lord. He has not complied the interim order. He came on a writ. He came on a writ appeal. During that interim period, Lord, the bank has auctioned the property. When we went to register the sale deed, then, Lord, we could not able to register because, Lord, he has defaulted the, Lord, the commercial tax also. And, Lord, the property was auctioned by the court itself. When none of them came forward to, Lord, for our auction, it was registered in the name of the court. So we cleared the amount. Then we registered the sale deed in favor of them, Lord, the respondent. So
Disputes which may be referred. Notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management, or the business of a cooperative arises among members, past members, persons claiming through members, past members, deceased members, between a member, past member, person claiming through a member, past member, deceased member of the society, its board, or any officer, agent, or employee, between the society or its board and any past board, any officer, agent, employee, so and so of any deceased between of the society, between the society and any other society. Such dispute shall be referred to the registrar. A claim by the society for any debt or demand due to it from a member of the nominee, heirs, or legal representatives of a deceased member, whether such debt or demand be admitted or not. A claim by a surety, any dispute arising in connection with the election, in dispute.
No, my lord, he is a member. There is a the cooperative, my lord, 70 jurisdiction is there, my lord. So my humble submission, my lord, for a very same claim, it is not in second dispute. It is, my lord, totally a different dispute. The first dispute only with regard to the 17 lakh rupees that he stood defaulted, came up to the writ appeal. Lord, in a writ appeal, Lord, a purchaser came forward voluntarily. He has given an offer.
Tell us one thing.
Yes, ma'am.
If he had not mortgaged the property with you,
Please, ma'am.
what is the necessity for you to go and pay his
Absolutely no necessity.
municipality dues?
No necessity.
It's a part of the same transaction, Counsel.
Well, the
That
cause
is
of
what
action
they-
arose, my lord, in the year 2007. We registered the sale deed.
Hmm?
Cause of action arose in a first dispute, my lord. It is in the year 2003-4. Lord, when we sold,
Question is not whether, when the cause of action arose. The question is whether this is part of the same
the
transaction or not.
only mistake which has happened, my lord, from the my lord, the council or the bank, my lord, he has not reported, my lord, the earlier transaction and the amount which is spent before the writ appeal court. But for which, my lord, they cannot be penalized.
It should have been done at the relevant time. Because what happens, there is a finding by this court, you sell the property for 35 lakhs.
Yes,
This court says 35 lakhs is not the value of the property.
it is sold
There is
for 50
somebody
lakhs.
comes up before this court and says, I will pay 50 lakhs.
Yes,
The court sets aside the sale and says that this person who claims 50 lakhs, that if the property can be sold to him, the deposit can be made, and whatever is left over will be paid to the landowner.
yes.
Then the court, whatever the claims were there at the relevant time, you're all before the court. The intending purchaser, the earlier purchaser, the landowner, the bank. And it is looked into by this court settles it and says, this is the amount due, what is the rate of interest, and what is the amount to be paid back to the landowner. Entire procedure is over.
Please, my lord.
We keep quiet.
This,
It is part of the same transaction. We are sorry, nothing can be done.
this is in public money, my lord. It has
It is
been.
public money,
a mistake.
therefore the bank should have been more circumspect. The bank should have informed this court that there was this money also available. We cannot do anything. We cannot, because it is even gone further. After the review, you take it up to the SLP. There also nobody has a case. In the review also nobody has a case. You raise all other contentions. There also no case. You have not paid 1,03,000 that you've been direct. You have not paid the
No, no,
1,03,000.
that order has been complied, my lord. That order has been
It has been complied.
complied. That order has been complied. There's no dispute with you. It's only, my lord, the second dispute which has been filed to recovery of
Have
my lord, the
taken
commercial taxes. that is
9% interest. They have taken.
Order passed by the KT recording a finding of fact that a separate dispute under section 70 of the Act before the joint registrar is not maintainable. Claim and cause of action in respect of the amount paid as taxes has reached finality before the division bench of this court and writ appeal. Said finding of fact recorded by the KT cannot be entertained.
That's my submission, my lord. It's incorrect because, my lord, these claim was not there, my lord, in earlier proceedings. So there is no bar to initiate me, my lord, for my lord claiming that amount.
It ought to have been there. Might and ought. He cannot reopen the proceedings.
No, that
Registrar
transaction.
could not have reopened. Registrar could not have reopened the proceedings. When it was before this court, this should have been raised.
That's at the
And at
mistake.
least at the time when the money was being repaid, at least at that time it could have been raised. He comes before this court in the review petition, he says money has not been paid. At least then, if you had raised that I've spent this much money for him, for his property municipal taxes. Therefore, at least absolve me of this liability to pay this amount. You didn't.
Ultimately, in a cooperative, blood management keeps on changing, blood the person to person.
We understand that, but we cannot reopen something which has been closed by this court. You had all the opportunity at the time of closing of the writ petition, then review petition, SLP, at least their liberty could have been sought to file a review. Now also a review could have been attempted, not done. You go straight and raise a dispute decided, you go before the KAT.
Please. Only to harass the respondent number one, the
There is
bank.
no harassment.
From earlier days, they are up.
Not a question of harassment. They've paid your municipal taxes.
Because of the
Normally,
mistake of the bank,
if-
he's been enjoying it, blood.
Absolutely. And they gave you the money also. We thought at least that much would be saved. We thought that had not been paid because we read in the review order that he raised a condition that that had not been.
That,
At least if you had left that untouched,
Yes, blood.
we had at least raised at that stage that there is amount due, therefore we are not paying it. At least that could have been salvaged.
That's blood in the whole proceedings, blood up to the blood writ appeal to the special leave petition. It is only for recovery of the blood loan which has been defaulted.
Correct.
So these would have been not arised. It has been arising blood in between the proceedings. So that has
It's
been
not correct. It is only because of that mortgage. If that mortgage were in there, there is no question of.
the first cause
paying
of
any-
action. That's the first cause of action.
First cause of action.
Yes.
Had it not been there, no question of your paying the
Yes.
municipal tax in respect of his property. Why would you pay municipal tax for his property? It is a charge of the property. Therefore, you wanted to clear the municipal tax and sell the property.
Yes.
That is why this happened. Now you sold, you paid the municipal tax. You either had to add it to the value of the property when you sold it, or you had to tell the court that there is such a claim. Therefore, when that 50 lakhs is being adjusted, 5 lakhs should have come to you, 5 lakhs and odd should have come to you.
Yes.
That would have been the proper way. Not done. Review file. They are also not done. Can be done.
One humble submission, that amount, 1,03,800, that has not been paid by the bank.
No,
Very
it
good.
has been.
At least that much. We'll not direct the
But
payment.
it is,
That we will not direct the payment.
it's
We'll
cost, cost may be imposed because litigation, poor litigants.
will not be imposed. This is also public money. If we impose cost also, it is public money. Yes. Merge the learned counsel. For the appellant. It is submitted by the learned counsel for the appellant. That the appellant is a cooperative society doing banking business in respect of its members. And that the appellant is aggrieved by the judgment of the learned counsel in as much as a claim raised by the bank in respect of 5,05 rupees, which has been paid by the bank as municipal taxes and dues in respect of the property of the first respondent.
First. Respondent
Of
one to
respondents
four.
one
Number
to
one
five.
to
One to four.
1 to
2, 5.
1 to
No,
4.
1 to 4.
4 million.
1 to 4 has been declined. Full stop. It is submitted that the that the appellant had in the year 2011 initiated a dispute under section 70 of the Karnataka Cooperative Societies Act against the respondents, claiming the amount paid towards commercial tax and municipal tax for an amount of rupees 5,25,006. The additional registrar of cooperative societies, by his order, had allowed the dispute, directing respondents 1 to 4 to pay the amount with 6% interest thereof. respondents 1 to 4 challenged the order before the Karnataka Appellate Tribunal. And by the order impugned in the writ petition, which was dated 26/9/2014, the Appellate Tribunal set aside the order of the registrar on the ground that it is a second dispute in the same cause of action, which is not maintainable. It is contended by the learned counsel for the appellant that the cause of action in respect of payment of rupees 5 lakh and odd as municipal and other taxes was a separate and distinct cause of action, and that the finding of the appellate tribunal was therefore completely unjustified. It is submitted that the earlier dispute between respondents 1 to 4 and the bank was with regard to a housing loan availed by the respondents from the appellant bank, pledging their property. It is submitted that the loan for rupees 35 lakhs was sanctioned, but after the first amount of rupees 17 lakhs was released, it was found that the respondents had committed fraud and sold a portion of their pledged property to third persons. It is submitted that the recovery of the loan amount was the cause of action in respect of the first set of litigations between the parties, which resulted in the judgment of a division bench of this court dated 12/11/2007 and writ appeal number 580 of 2007. It is submitted that it was in the months of April to June 2007 that the payments had been made by the society, and that the said payments towards municipal and other taxes amounts to a fresh cause of action. Full stop. The learned single judge had considered the contentions and had found that the dispute with regard to the loan availed by respondents 1 to 4 and the sale of the property by the bank had been considered by this court and came to be decided on 12/11/2007 by the judgment of a division bench of this court in writ appeal number 580 of 2007. The division bench found that the sale of the property in question for rupees 35 lakhs was not proper. And in view of the fact that a offer was made by one Uttegowda, the fifth respondent of this appeal, to buy the property for 50 lakhs, the said offer was accepted by this court, and the sale and the sale certificate issued were set aside, and the sale was directed to be confirmed in favor of the fifth respondent for the amount offered by him. The division bench also considered the claims with regard to interest and directed payment to the prior purchaser under the sale certificate, as well as the refund of an amount of rupees 1,03,830 to the to respondents 1 to 4, the owners of the property. Full stop. It is contended by the learned counsel for the appellant that at the time when the writ appeal was being considered, the question with regard to payment of the municipal taxes, municipal and other taxes, was not brought to the notice of the bench considering the matter by inadvertence, and that therefore the same should have been considered. It is submitted However, the learned counsel appearing for the, don't say submit. However, the learned counsel appearing for respondents 1 to 4 would contend that the payment of the amounts by the bank in April and June 2007 was only to make available the land for sale. And that it was an incidental expense which was availed by the bank, which was suffered by the bank for making the property saleable. Full stop. It is further contended that this fact not having been brought to the notice of the bench which was deciding writ appealed 580 of 2007 on 12/11/2007 or in the later review petition which was disposed of on 16/4/2008 or yet later in the special petition filed by the bank before the apex court. The said contention cannot be raised as a separate transaction. Full stop. Having considered the contentions advanced, we notice that the learned single judge has considered the specific contentions raised by the appellant and has held specifically at paragraph 15. Paragraph
7.
Paragraph 18 of the judgment under review as follows. 18 and 19.
70.
We notice that the amount allegedly having been paid by the appellant on 17/4/2007, 12/6/2007, and 5/6/2007, while the writ appeal was pending, it was for the bank to have brought the fact of this payment to the notice of the bench deciding the writ appeal. Having not chosen to do so, we are of the opinion that the raising of the dispute on the ground that it is a separate transaction and a separate cause of action was completely devoid of merits. We find no material to disagree with the findings of the learned civil judge in the judgment under appeal. The appeal therefore fails, seems accordingly dismissed. Only thing we can do is we'll not say anything about the 1 lakh. Yes.
42, Joseph Tanikraj.
Yes, this is that case where one firm is stopped and another is started. Same persons.
Yes, yes.
And same employees also.
Almost similar employees.
Now they have produced those documents, my lords. Many documents have been produced to show to substantiate their claim that it is separate. No, that would itself shows that nothing was produced before the trial court.
That company was not a party before the trial court.
Two things. One is that the documents produced here, it is not an appeal as a continuation of the proceedings.
Please, ma'am.
Appeal is in the nature of a section 100 proceedings.
Please, ma'am.
Substantial question of law only.
Please.
Therefore, whether we can consider the material which is produced here, if it were a first appeal, a normal continuation, then we could have probably looked into it.
Please, ma'am. My contention is the documents which are produced pertains to a separate establishment who are not parties before the trial court. No claim was made against those respondents, those parties. So therefore, they could not have produced those documents while the trial was going on in respect of some other establishment. So now to show the court has come to a conclusion that all the 3 establishments are one and the same. Now to show that they are not one and the same, and these 2 separate establishments have been covered under the provisions of the ESA Act, and to show that they are paying ESA contributions in respect of their employees employed by them, I have produced these documents. So therefore, these documents are necessary to come to a proper conclusion. Because there cannot be dual contributions in respect of the very same employees, in respect of the.
Anyway, being an appeal, we can consider what those documents would say.
And I have produced the
If
documents.
If as a matter of fact, for the very same period, for the very same employees, they've paid contributions for, in respect of the very same employees in another establishment. Probably.
What I try to submit, my lords, is that, lords, there were two occasions to them. One is when the notice was issued initially, asking them to pay. They
Correct.
could have produced it and shown it. It's in the year 2012.
Correct.
They don't produce anything. Later on, they file an application before the ESI court. Even then also, main issue is that, my lords, that they're separate entity, and if they're covered,
If they are actually paying the contributions in respect of the very same employees by another establishment.
lords, if the
That is the contention.
applicant shows
Yes,
these were the employees,
yes.
they are covered under this. I am
Yes.
paying it. So this is not correct, is what they
Correct,
could have
correct.
said before, even
Correct.
before the ESI court. They don't say anything. They take a order. After the order is there, my lords, when the substantial question of law is framed, earlier they had filed one application saying that some employees we have taken. They don't say who are those employees, nothing in the application. Now they file a compilation of entire documents saying that
So if this was available to them, it was for them to have brought it to the notice of the
Anyway,
court at the relevant time. If they don't, they lose that.
my lords,
Chance is
they
your
can't
contention.
find error with the ESI court, my lords, when
Correct, correct,
finding is given.
correct.
Now, after it was admitted and substantial question of law is framed, these documents are additional documents are filed. Lords, that shows that it's not wrong. ESI court was not wrong because nothing was produced before it.
And probably this was not available with
Lords,
them.
it is not their case that I did not have. Lords, there are two things, my lords. They don't have that document with them. Now they have found out. Yes.
Correct.
Here, their case is, I have taken, there were nearly 290 employees, my lords. Out of that, two different entities have been formed. They're saying we have taken few, maybe 119 or we don't know exactly. We don't know anything. If they have taken, my lords, it was with them to that extent at least.
Therefore, what prevented them from
Producing it.
before the ESI?
Now they can't say after everything is done, they can't find fault with the ESI court.
That is not my case. My case is this order was passed in violation of principles of natural justice. The notice that was sent to the appellant was not functioning there. Some other establishment was functioning there. This notice has been served on some other establishment, not in respect of this appellant establishment. Because of the confusion in the name.
May not have been the same establishment, but the management as well as the employees are the same.
In the same place.
No, that is not my case. My case is, it was a partnership firm consisting of two partners. One Niaz Khatib and Javed Khatib. They are siblings. There was some dispute and differences between them. They were not in good terms. So therefore, what they did was,
Take a look at what those are. What the documents are in there.
they decided to close company. This is a partner registered company where the directors are different. Maybe the partner, one of the partners is a director.
This is not PG cost.
It is not. That is, sorry. No, we were wondering what further in PG dates. Not filed. Not filed as yet. Filed because no number is given. Can you please provide the number, please? Please give the number.
Passed over matter, list one, seal number one.
One of the judges has come from Dharwad.
That has to gain precedence, absolutely. Yes. Yes.
We are concerned a lot with the land bearing survey number 148 of Guttu village, measuring 2 acres, 1 gunta. It was not granted in favor of one Sri Ramaswamy Iyengar, Lord, in the year 1942. First serial number 1, under what is known as a Gomor Food Scheme.
Promo.
In 1965, Lord, on the ground that there has been violation of the condition of the lease.
Yes. The scheme.
Lord, the Deputy Commissioner Bangalore next week, Lord, cancel the lease. Page, Lord, annexure R1, page 305, Lord, we have placed it for your lordship, 305 for your lordship.
Section R1.
Yes, Lord. 305.
Circumstance report by local officers, GMF lease of land made out in survey number 215 Blue Village in favor of so and so is cancelled as he has sold the land and has violated the conditions of the grant.
Correct. It is cancelled on the ground of violation of the grant. Then, my lord, subsequent there to my lord in the year 1980. What is it? And then, my lord, second paragraph itself, my lord, in that page 3.
Yes, an extent of, yes.
Is confirmed in favor of Vaddara Udaga, whose, my lord, legal heirs are, my lord,
Father of the good.
Then, my lord, page 380, 307, if your lord is come. That's, my lord, the type copy. Sorry.
Yes.
309. Grant certificate in favor of Vaddara Udaga. Get that, not English translation. That, not page 318. 380.
Yes.
If you are not to come to 321, the details of the land, my lord, are given. 321.
Yes.
315, my lord, in favor of this. Was, my lord, there is what is known, my lord, the once, my lord, it is granted, revenue entries have to be made. Please come to, my lord, the page 186 onwards. Entries are all made, my lord, in our name. Children of Vaddara Udaga. 186, my lord.
Yes.
I think what is it, my lord? Column 9, my lord, in the middle, my lord, get at the top. What is known as a column 9? Sorry, my lord, that is survey number 215. Then, my lord, come Setwaru something. Thereafter, there is a 2 acre 1 gunta, that is excellent. And revenues to 2 rupees 99 paise. Father's name, my lord, Muniswamy, son of alias Vaddara Udaga.
Swami.
Alias Vaddara Udaga.
That is, my lord, the extent. Then, my lord, please come to the bottom itself. Next page. 70 to 73 onwards. What the Budaga, my lord, his name is there.
Yes.
Then, my lord, page 192, 74, 75. His name, my lord, continues to be reflected. All along, my lord,
Yes.
198, 204, 216, my lord, I put it in my list itself.
Yes.
198, 204. Thereafter, my lord, what happened was after a lapse of 37 years, his name came to be deleted and the name of one Somashekar came to be entered in the revenue records without even a notice, my lord, to Vaddara Budaga or his legal heirs. Therefore, my lord, a representation was given to the Tahsildar by, my lord, the children of, by then, my lord, Vaddara Budaga had died. Therefore, my lord, his children gave a representation to Tahsildar. My lords may come to, my lord, page 217, annexure R10. English translation is the requirement.
Pramod. Rest of the matters.
Don't think, my lord, it should take more than half an hour, I think. So, I know, ma'am. Because
Yes.
not such a lengthy bill, my lord.
Yes,
The
yes.
short question is, what has happened is, learned single judge will not say, go to the civil court. I should go to the civil court. My title is never questioned. His title is under dispute. Therefore, my lord, if at all, he has to go. That's the short, my lord, issue that I'm trying to canvass before my lord. My lord, please come to page 226,
226.
226. my lord.
Yes.
This is, my lord, the Tahsildar's report. He sends it to, my lord, the assistant commissioner. See, my lord, subject.
Yes.
Representation of Shri Jairam, son of Vaddara Budaga. My lord, by then, my lord, Vaddara Budaga had died.
Correct.
Therefore, my lord, his son gave a representation to the Tahsildar saying that requesting to change the kata in his name pertaining to the land bearing 215, so and so, so and so. In connection with reference, my lord, and comes and then the report. In connection to the above cited subjects on and a reference and in pursuance to the report of the revenue inspector, the land measuring 2 acres, 1 gutta in survey number 215 of Kudlu village, so and so has been granted to Vaddara Budaga, but kata was not made. He died in the died on 3/6/1980. Kata, my lord, was made. This is, my lord, a small mistake. Hence, applicant Jairam being the legal heir is requesting to change the kata on the legal heir basis. Whereas it could be seen that as early as 1930, kata of the land measuring 2 acres, 1 gutta, which is the original survey number 148, acres assigned as 215, was entered in his name. According to the existing documents, land measuring 2 acres, 1 gutta in survey number 215 has been subject to sale as early as 14/6/1946. By this being so, land bearing 215, which was restored in the name of inter-alia, being sanctioned under survey number 148, has been again granted in the name of Vaddara Budaga, alias Muniswamy, as per official memorandum of so and so, so and so, and so, dated so and so. Then, my lord, so, my lord, he gives a report to the assistant commissioner. Pursuant which, my lord, assistant commissioner, my lord, registers a case. Please come to, my lord, running page 135. Type copy, my lord, better copy is at 139. Sometimes, my lord, in the type copy, there are mistakes. Original is better.
This is that page.
No, my lord, 135 is, my lord, the order.
Yes.
139 is a type copy.
Yes.
My lord, many a times in Kannada, my lord, we have, when it is translated to English,
That's
they murder both, my lord.
right. I agree with you. Yes.
So, this is what, my lord, the revenue, my lord, the assistant commissioner, based on the report of the Tahsildar, my lord, holds that, my lord, my name, my lord, should be restored. Therefore, my lord,
This is challenge before the deputy commissioner. If my lords come to my lords, page 138. Last paragraph. If the
Yes.
circumstance is ordered to effect the land in survey number so and so, situated good room, Sarja probably unable to whatever the Elias Paniswami land, is instead by inheritance, name of the appellant according to this position in your. Then, my lord, this was challenged before the deputy commissioner. My lords get that at running page, my lord, 143.
Yes.
Respondents, my lord, challenged it before the deputy commissioner. Deputy commissioner, my lord, confirms the order passed by the assistant commissioner.
Yes.
This is challenged, my lord, in a writ petition by, my lord, the respondent to my lords. The learned single judge, my lord, allows that writ petition. And my lord holds that, my lord, I must go to the civil court. That's why I said, my lord, short question is, who should go to the civil court?
Yes.
Because my title, my lord, is not under dispute. Government, my lord, files, my lord, says, my lord, this grant is cancelled. It was granted, my lord, on a lease basis, not even, my lord, as a say, as an absolute ownership of the property. It was granted on cancelled, my lord. And, my lord, it was granted to me, my father. And, my lord, the revenue records have all been, my lord, in my name. Therefore, my lord, my submission to your lordship states. Please come to, my lord, paragraph page 38 of the learned single judge court. Starts at 26. Sorry, 37, 37 if your lordship come. But I read from paragraph 8 on the previous page, so that one there's continuity.
Yes.
Official memorandums, the official respondents have filed their statement of object. Tahsildar Anekal, third respondent has verified the statement of objection on behalf of the respondent. It is stated that Shandro Ramaswamy was granted land mentioned to take the Sandunda and survey number 2 of 2. On 27/5/1941, no more scheme, and he has sold this land in favor of Muniaka under the safety dated 14/6/1940. Why is it considered that? Therefore, the grant to give by order this one. Therefore, neither the transfer by Sri Shango Ramaswamy nor the subsequent transfer by the transfer can be valid transfer. And these transfers cannot prevail over the grant in favor of Elias Paniswamy. As regards the question of identity of the land granted to Ramaswamy Shango Ramaswamy is ultimately purchased by the petitioner under the sale dated 4/5/1958. Petitioner is not the respondent. And the land allotted to Vadarabaga, Tahsildar Anekal, the third respondent, asserted land in survey number 215 of Kulu village, Sarjapur, Anekal Taluk is carved out of the larger land in survey number 148 after necessary survey proceeding in the year 1930. Though this land is granted to Shango Ramaswamy Iyengar, grant is later cancelled and the land is allotted to Sri Vadarabaga, Elias Paniswamy. Third respondent is also asserted that the revenue increase in favor of the petitioner or the land in survey number 215 of Kulu village, Sarjapur, Anekal Taluk, were based on invalid document, and therefore revenue entries could not have been validly made in favor. As such, the assistant commissioners intervened with the order dated 15/2006, restoring the revenue in favor of Vaira, who claims under Vadarabaga against this. He so and so, the senior counsel for the petitioner argued. Assistant commissioner set aside the revenue entries in favor of the petitioner in excess of jurisdiction and 136 over KLR. Jurisdiction under provision under KLR Act, the statutory ability available to a person who is affected by an order under 129(4) or entry certified under section 129(6) of the KLR Act. And such a person must exercise the right to avail appellate remedy within 60 days from the date of communication order or the knowledge. The assistant commissioner cannot so about to initiate proceedings next day to the section 136. And if a belated appeal is presented, this jurisdiction can be exercised only upon underlying date for sufficient reason as contained in section 5 of the limitation. Please so and so, then he refers to my lord several judgment. Now, my lord, please see, my lord, the reasoning of the learned judge. My lords come to page 9, my lord, 49 at paragraph 9b.
Yes.
Sorry, lord, 18, but just the previous, so that my lord is.
Yes.
17, my lord, their lordships, my lord, hold that, my lord, respondent, official respondents are, my lord, holding that, my lord, there has been cancellation order. 18. There is no dispute that the second respondent has registered the appeal in RA number 140 in the following circumstances. Fourth respondent has filed an application with the third respondent for change of charter for the land in survey number 2, measuring 2 acres, 1 gunta, village. After report dated 17/4 by the revenue inspector Husku, Deputy Tahsildar Anand has filed a report dated 22/4/2006 recommending cancellation of charter for the subject property in favor of the petitioner and mutation in favor of the court. Tahsildar Anand has later filed his report dated 24/6/2016 with the Assistant Commissioner in line with the Deputy Tahsildar's report dated submission. Second respondent, on receipt of this report, dated 24/6/2016, has registered the proceedings under section 136 and has issued notice to the and the revenue authority. It is observed in the second respondent's order dated 15/12/2006 that notice sent to the petition by RTA is returned with endorsement is not available. Firstly, this court will have to consider whether the second respondent, given the provisions of chapter 11 of the KLR Act, would have registered the appeal under section 136 of the KLR Act without a memorandum. And if the second respondent could not have registered the appeal, can the ensuing orders be sustained? Secondly, whether the present controversy between the petitioner and the court's respondent can be examined under the provisions of chapter 11 of the KLR Act. Provisions of section 128 and 129 of the KLR Act must be first referred. These provisions provide for the following: 128(1) reporting either orally or in writing of any acquisition of any interest in agricultural land by succession, survivorship, inheritance, partition, purchase, mortgage, gift, lease, or otherwise. Any rightless holder, occupant, owner, mortgage, landlord, tenant, or the landlord assigned of the rent or revenue thereof within 3 months from the date of such agreement. 128. Issuance of notification by the state government to appoint any revenue officer to whom a report under subsection 1 could be made, in which case such officer must give a written acknowledgement of the receipt of such report to the person making it and forward the report to the prescribed officer or the village concerned. 128. Report by the registering authority when acquisition is by a registered document, and in fact this provision stipulates no document by virtue of which that any person requires any right to any land as holder, occupant, owner, mortgagee, landlord, or tenant, or assignee as a renter, shall be registered in the Indian registration unless the person liable to pay registration fee also pays the registering authority such fee as they will prescribe for making necessary. Provisions of section 129(1) of the KLR Act provides that every report under 128(1), 128(2), or 128(4) shall be entered in the register of petition, giving written indication to complete of the conspicuous basis of objections are filed, either orally or in writing with the prescribed officer. Such officer shall enter the in the register of disputed cases. Provisions of section 129(5) stipulate that objections entered in the register of disputed cases and other objections as may be made during the hearing shall be inquired into, disposed of in such manner as may be prescribed. Provisions of section 129(5) stipulate that an officer holding an inquiry under section 129(4) shall have all the powers of officer of a revenue officer under chapter 3 of the KLR Act, that a revenue officer has in making a formal or summary inquiry in the KLR. It is only against an order under 129(4) and certification under 129(6) and appeal and further revision is contemplated in 136 of the KLR, which reads as under. 136 reads thus: provisions of this chapter, chapter 5, shall not apply to any decision or order in this chapter. Any person affected by an order made under subsection 4 or an entry certified under subsection 6 of 129 may, within a period of 60 days from the date of communication of the order or knowledge of the entry certified, appeal to such officer as may be prescribed in the state government in this behalf, and his decision shall be final. The Deputy Commissioner may, on his own motion or an application of a party, call for and examine any records made under subsection 127, section 127 and section 120. Pass such orders as he may deem, provided that no order shall be passed except after hearing the party to be adversely by such order. It follows from these provisions that if the report is made either under 128(1) or 128(2) or 124 for the KLR Act, prescribed officer must enter the same in the register of petition. Entries must be posted in a conspicuous place in the town. And if objections are filed, either orally or in writing, inquiry is contemplated in the section 129(4) of the PLR Act must be paid in the prescribed manner. It is against these orders, which are a decision on the objection filed and the subsequent certification of 129(6) of the Act, appeals under 136 is provided with the further remedy of revision under 136. This court must opine that only because a report is filed under 121, 2, or 3 of the PLR, appeal proceedings cannot be registered in 136, 2 of the PLR. If a report is filed as contemplated in the 128, due process of notice and inquiry, as contemplated in the section 129 of the PLR Act must necessary. The person is agreed by an order thereafter can then avail of remedy under section 136 of the PLR. This court must at this take the decision of the division maker. Distinction between a right of suit and a right of appeal, I'll leave it at that. May not have much of a bearing. Now, my lord, please come to my lord, running page 59 at para 26. This court must open questions whether Ramaswamy, Shango Ramaswamy Iyengar and both respondent father alias Maniswamy are granted different lands or not, and the status of the respondent's claims of possessions are questions of fact that impact the claim. And these questions could have been decided in the proceedings under chapter, could not have been decided in the proceedings under chapter 11 of the PLR. This court must refer to the decision of this court in Dema versus State of Karnataka, represented by the Secretary, wherein it is held. The revenue authority, namely Tahsildar, Assistant Commissioner, Deputy Commissioner, have no jurisdiction to decide the title dispute between the parties in respect of immobile property or property. It is the exclusive domain or the competent civil court to adjudicate the dispute or title in respect of the immobile property or property. And ultimately, for a decree, if any decree is passed by the competent civil court, will be binding on the parties as well as the agreement. Any order passed by the jurisdiction Tahsildar under the provisions of section 129 of the PLR Act touches the title in respect of immobile property. There is no need for the aggrieved party to file an appeal or as it is a futile exercise, and therefore the aggrieved party can straightaway approach the competent civil court for declaration of title and consequential and decree to be passed will be binding on the parties. Then, this is what the difficult bench has said. Then please come to para 26. Both respondents' right to revenue entries for the land in survey number 2, measuring 2 acre 1 gunta of Google video, Sarjapur Hubli Anekal Park, will require education questions which will involve decision on the alleged change in boundaries by the petitioner's predecessor in the same deed, executed by them, identified of this land. These questions could not have been decided by the revenue authority. Therefore, impugned orders will have to be. Consequently, revenue entries in the land for the land in survey number 215, measuring 2 acre 1 gunta of Google village, Sarjapur Hubli Anekal Park will have to be restored in the name of the petitioner, subject to the decision in this suit that may be filed by the fourth person. Insofar as orders and dated so and so, the deputy commissioner this court must observe it will be contingent to the petitioner establishing his case and can avail to him if he succeeds in the suit. He may institute. Therefore, the following. But the order is set aside. But my submission to the Lordship is 4.4. 1. The first contention that was canvassed and that was accepted was, I did not file an appeal. Therefore, my lord, this was not maintainable. My submission is that I gave a representation to Tahsildar. First of all, my lord, it is an undisputed fact that, my lord, their predecessors grant of these, my lord, was cancelled. If that is so, my lord, they cannot get, my lord, any right, my lord, in respect of this property. That, my lord, the property both of us are claiming, my lord, is to be undisputed. If that is so, my lord, my submission to your lordship says, I have given a representation to Tahsildar. Tahsildar, therefore, my lord, refers to the Assistant Commissioner, who, my lord, hears both the parties and, my lord, passes an order, which, my lord, is challenged by them before the Deputy Commissioner. Learned single judge holds that the court, my lord, the revenue court can't go into the title. My lord, absolutely correct. I don't, my lord, have any quarrel about it. But the fact is that, my lord, my title is not disputed by anybody. His title is disputed. Therefore, my lord, who should go to the civil court? That's the issue, my lord, because what, my lord, the learned single judge has done, it is an undisputed fact, my lord, our name was coming all along. That is, my lord, all of a sudden cancelled. His name, my lord, is entered.
Who is the possession book?
We are in possession, my lord.
Status quo ಕೊಟ್ಟಿದೆ.
I shouldn't have asked.
In fact, we had, my lord, stopped by an interim order.
Not to cut the tree into they made the application that is status quo has been done.
That interim order was granted. That would show that we are in possession. That's all, my lord, more than that. But the fact is, the one that, my lord, there and my lord, was cancelled is, my lord, not challenged by anybody. If that is so, my lord, who should go to the civil court? That's the only issue, my lord, before my lord. My submission to your lordship says that, my lord, it is he who has to go to the civil court. My lord, what your lordships have seen is, learned single judge, my lord, restores the name of, my lord, the respondent, before your lordship, the petitioner, my lord, then, my lord, especially in the light of, my lord, all along, my lord, my name was there in the revenue.
When was it? When was the name of the? respondent
2006,
entered
my lord.
in the first, for the first time, 2006.
1 minute, but I tell you. Let's see.
Hello. Nanda.
2006. 2006 is the order to restore your name.
Please,
So when was the?
please. 216 and
216, I believe. 216. 216. No. When was his, what the judges are asking, when was his?
Yes, nothing.
98.
Ninety-three, 94 till 93, 94. It is
Vaddara Budaga.
Vaddara Budaga.
ಅವರದ್ದು ಯಾವಾಗ ಬಂತು ಅಂತ ಹೇಳಿ. When did his name come to be entered? Because they have also not filed. We don't have it. No, just check. We also didn't find it. ಇಲ್ಲಾಂದ್ರೆ ಇದೆಯಾ ಅಂತ ನೋಡಿ. This leading will not to show that. I didn't find anywhere. Because we might have different way in a better position to document. What my was because that's what they want. Yes, I didn't find it.
2006.
MR number 23 of 98, 99.
Yes.
Yes, MR number 23 of 98,
98, 99, 24, 98.
Yes, 98, 90. Okay, I just wanted to know when.
Yes.
Yes. Yes.
My submission to your lordship says that, my lord, after hearing both the parties, my lord, these orders came to be passed. It's not that my lord, the question of title was gone into in that sense. It's an undisputed fact, my lord, that it is not challenged. Therefore, my lord, it is not like a title dispute, my lord, which is now, my lord, agitated before a civil court. It is, my lord, based on the revenue entries itself, my lord, and the admitted documents that, my lord, the transport, my lord, the authorities, my lord, have put back our name. Therefore, my lord, my submission to your lord says that, my lord, the cancellation of my lord name was not proper to be my submission. And question of my being relegated to the civil court does not arise. At best, not he should have been relegated to the civil court. That's all, my lord. I don't think
Yes. Yes. 24/1/22. Hmm. Hmm.
And also recorded date 10/6/1944, which we now something here, the land in question. Further, we are 27/5/1946, you are here. The same person we have by any land in question in favor of the third villa, all you are living in on. The same digital say this particular exception. So last week I appreciate. Either the present appellant's father. Whatever Diga is the present appellant's father. May request my lord, the next document is crucial to lordship paying consideration. That is 10/7/1967. The present appellant's father. You will ask me kindly appreciate the matter of Diga sold the property in favor of create popularity. And that is placed before the Honorable Court, Annexion D. So like a kind of this is the point, and the present appellate father, you will not be kindly also okay. 1/6/1998, the date of death of the father of the daughter of Diga. I show father of the appellate. The date of the appellate father died on 1/6/1998. That is all 9 years. Further, my lord, on 17/7/1972, K. Popularity alien this land in question in favor of Iraq. That is the my vendor. The on 4/9/1995, Veerappa alien this land in question once again in favor of Raghuram Reddy. And the Raghuram Reddy sold his property in favor of me. It is by virtue of a registered sale. By operating plus one, there is a 4 or 5 transactions. That is a crucial point for monarchic payment method. There are trades in 1998. There was a transaction of the sale. Prior to there are 2-3 sale deeds are executed. The present father executed the sale deed in 1967. So last week, kindly appreciate the 4/9/1998 MR was affected, given effect of 23/24/1999. So last week, kindly further, my lord, the key or my father, that the appellant's father was passed away on 1/6/1998. After father passed away in 98, the first time after lapse of 8 years, the last week, after lapse of 98 years, the surprise the present the appellant gives an application to the Tahsildar prepares a report, and he submits the report to the Tahsildar to AC. AC two more initiated proceeding after a lapse of 8 years of 1998. After the death of the father of the father died in 98, then during the lifetime he never initiated anything, and he surprisingly he initiated proceeding only in the 2006. The last time kindly appreciate. Next, this is an expert order. The AG passes the expert order contrary to the provision of the section 29 of the Karnataka Land Revenue Act. The last time kindly without the completion of the process, the procedure for service of the one, there has been the expert. That order is called question before the view of the order of the AG. May I request my lord at the page itself, what exactly the case of the, that is the case of the present existing appellate before the revenue authorities and before the TC and the AC. Now may I request one party is relevant. but I expect the order, while others in the pointed out, you will expect to appreciate the page 139 is the type copy of the AG order. Page effects a lot, one party is 11.
Yes.
That will be available record. During 1946, H.V. Ramaswamy had alienated land in favor of one Muniyappa. And from this time, Pattal Muniyappa, the Muniswamy has purchased the land. But there is a quite different boundary of the land in original survey number 215, purchased and the survey number 250, subsequently the Vandara Putiga, Alia Muniswamy, the land in survey number 250 in favor of Gopala Reddy, son of Gopala Reddy subsequently. Gopala Reddy has alienated land in favor of Chikkaya during 1972 and subsequently it is alienated in favor of Veerappa, in favor of Ganguram Reddy, Gopala Reddy, and that later. Boundaries were different, so that we kind of forget the order of the being that is by the Assistant Commission were different. The land is alienated in favor of Sri under the legitimate deed 98 and accordingly Kata standing in the name of Somstika, that is the present contesting respondent number 4, Chapter 13, 23 and 24. According to this text, and you will have to make it ultimately passes an order. The DC order may impact according to the definition. With the relevant point of 140, 140, 1 minute. And why from the DC order start from 143 to last relevant paragraph 11 is 149. Page 149. This is relevant. That will be seen on the record. I try to work a lot. That will be seen from the record and the order of the Assistant Commissioner. Notice was sent to the petitioner and other respondents has been required by the postal authority. However, even though considering the content of the petitioner, as well based on the report of the Procedural, on the finding of the State Commission, clear and claim petitioner in the land 250 is quite different. Well, I may kindly try to find out what I hear the finding of the revenue authority. Well, I may finding of the Deputy Commissioner is like what I try to find here. You are right to make I authority to provide out the objection statement filed by the contesting the appellate hearing. So that may at page 164 before the learned single jet, the objections are filed. So that's make Now, I find out from the objection statement that taken by the present appellate hearing. So that's may just I find out paragraph 4-6 at page 169 starts and 170. So that's the fourth respondent, paragraph 6. The fourth respondent saying that actually the land extending to in survey number 2 of Food Village, which is earlier purchased by the fourth respondent on 27/43. We situate towards the south side of the land in survey number 207 and 298 and 209. And boundaries of the said land in the state is also says same boundaries. Further, the said land was sold to Gopala Reddy on 10/7/1967 itself. Thereafter, the said Gopala Reddy sold to Veerappa on 17/7/72. Further, in turn, the same Veerappa and the same to Ganguram Reddy on 4/9/1995. In this transaction, both Veerappa and Ganguram Reddy taking collusion each other, changed the boundaries and survey number 211 and 212, not
This change of boundary made by the bill of Abandonment only in the interest of grant other land which is granted in the 73 bill of Muniswami, who is the father of the fourth respondent. The copy of the revenue sketch is prepared by the Surgeon. This creates that clearly indicates the land purchased the smallest father in 46 different one and the land invaded and the revenue is also another land. But as both lands situated to the same survey number, the extent of land bearing the same. However, the boundaries are different in the location. And different actually there is a one more the 1 kilometer traffic distance between these two lands. However, the petitioner made already and this paragraph is below. This paragraph is further below. The fourth respondent submitted the petitioner hearing who admits all the transactions on 10/6/44 to 25/46 and then 77, 77, 72 and 490. But also the presently the change of the boundary is the same clearly dated 4/19/95, which is contrary to the earlier 4 transactions. Therefore, it creates the petitioner intentionally. This is the objection while before in the inspection. They dispute the permissible actor. What I try to point out from the objection statement while by before the learned signal, they specifically dispute the boundaries of the land which is now where they provide the boundaries and the so the file for consideration here. So we have my learned and as here who should here so that's the value of the state. The true mode of proceeding is participating in the basic two. That is the order of the learned signal that is well known that something there is something report on the effect. So what I say in fact when serving the case in the 1998 I purchased a property of property. Right to control there are 4 transactions. This was 1967 and 72 and later it was 4 to me. There are 4 transactions here for 4 to me. So here the after 1981 was effected in 1998, 23-24 MR. Now both the revenue authorities FFT MR order. So they fight for your pay consideration. After the lapse of 8 years, here the present appellant files an application before the no application is filed, only gives a representation to the Tahsildar and in pursuit of the Tahsildar in lieu of the representation, he prepares a report. That report has been submitted to the Assistant Commissioner. Assistant Commissioner resumes the jurisdiction of consultation to that is arbitrated in chapter 9 of the Karnataka Land Act. There is no delay application. In fact, it did 6 years or 8 years. So there is no delay application, and he resumes the jurisdiction under 136. Power exercised under 136 contradicting law. That is my first submission. That is my first point for consideration. The 136 provide for 160 days. We are providing for 160 days to file an appeal before under 136. No, my lord, yes, my lord, the fine for the ultimately, my lord. No, it is a undisputed fact from 1998 till now, having purchased physical purchase and examined land in purchase. All the mutations are changed in regulatory RTC case. So since from 1998 till now, I am in physical purchase and examined. So I can take it the order of the RTC case I try to brought to that kind of thing. There is a lot of in the conversion order and there is conversion and also recent recent mutation has been also produced even for the current year also. But actually out of the limit the image of the term of code right like so that may agree. I show it may respect a lot the what I know I will complete before the term of code permit to be to break document. So that may agree. First document is the conversion order on 29/11/2023.
These are new documents which are not even placed before Any of the authorities or before the second.
And the revenue entry may be kindly be shown. I present the earlier revenue entry before this court. On 24-25, the name of subject at the present and court respondent name by the page at page 15, document number 2. What I try to find out from all these records, respectively, but in the respectively, the order of the implementation of this honorable court dated 28 January 2022 is relevant for the last country. Next, I read the order of the implementation of this court. And I have one first state, keep it in the appeal before the court. And then the division may pass on an order. In the meanwhile, the respect of the condition for to respond by one day. In the meanwhile, the appellant and the respondent number 4, including one, shall not take any precipitating action to cut and remove the tree in survey number 2, machinery it is an interim arrangement. It is an very request law. There is a serious issue related to the identity of the property, but we whenever the law, the division of this court, and if there is a serious from the economic as the objections before the learned single date categorically clearly mentions to there is and only put a back date include the boundary and the date of the right to the close there was a transaction and there is a thing from 1998 till now I am in physical possession and now the whatever the order of the learned single date the ultimately the learned single date passes an order. Next I find out from the order of the learned single date page 62 order. The writ petition in WP 10499 2011 is allowed and the order of 3/12/2006 very second responding and the order dated 1/10/2009 in review petition 71 of 2007 and 8 very first husband or wife and consequently the revenue entry for the land in survey number 250 measuring to a girl 1 good of the land on a girl column shall be restored in the name of the petitioner subject to the decision any suit that may be filed with the both respondent. There is specific finding by the learned single date in considering the case as a whole and considering the facts and circumstances of the case, when examining all the documents placed before the learned single date, even in the additional subjection statement they produce this in the document, all the documents are relevant position of law and we ultimately there is the well-founded order. They dispute the boundaries. They dispute the boundaries and their own contention they raise in the objection. Ultimately, the letter single date of opinion, they have to approach the civil court and ultimately subject to the jurisdiction of the civil court and so far in there is claim that that is my submission. So that's my way of saying, you know there is an identity of the property that is in dispute. And that in fact the so far my child transaction is the right to the 3 or 4 transactions. And the fact that the order of the transaction is well founded and with all reasons order and that's you like to take the present of the has to be. Yes, my lord. Before the ACA is kindly, my request of the kindly to the date of the before the ACA they themselves are specifically contained land certificate and because the land inspection is different, identity of the property before the ACA. When settling the case, it is ultimately the present appellant approach the civil court, not the respondent of the court. The fact that the process of this case, like I say, this is a big case, like we can mainly explain.
Is it your case, only for clarity, is it your case that the property which had been granted to Shanbog in the very same survey number, 2 acre, 1 gunta, and where that grant has been cancelled by Exhibit R1. Is it your case that that is a different property? There it appears that in respect of that property, while the person could have sold it to you or your predecessor in interest, only he had a title. Chanbok what is his name? Ramaswamy Iyengar. So it appears that there is an order at annexure R1 where grant of 2 acre 1 gunta in favor of the H.S. Ramaswamy Iyengar is cancelled for violation. And that very same property, an extent of 2 acre 1 gunta of land is confirmed in favor of Vaddara Budiga at an upset price of so and so, as recommended by local officers. This is in 1965. After that, at least till 1998, Vaddara Budiga pays the, his name is entered in the RTC and he pays. He pays the land tax. Then, if that is so, unless do you have a case that this is not the property at all? Is that your case?
1967, the present appellant's father transferred the property in favor of popularity. They also accused the property in question was sold by popularity. Popularity is not which want to be a part of.
Which is that document that you say that it is?
My appeal. Connection email. Page 111. Another 14 title combination.
116 is the translation.
Another 60. Absolute say read dated 10/7/1967. You like to translate copy 1161. This is the absolute say read dry land included on this of the 1967 popularity the referring schedule. Executed by Muswami alias Vaddara Budiga, that is the father of the present contesting appellant. So you are not to pay
Which is the, where is the schedule?
schedule there are measuring 2 acre, he could have 170 million. The space of the will be loaded on each by 117 last 2 lines, 4 lines. Each by government, government law, not by Munigaraga and Tulabanga, the south by where leading to go on this land. This was not the case also, the appellate, it was the land is cancelled or it was there asking for the
That is correct. But this is only this 1967 document. Means that it is part of state for the obligation. So 67 says the rules also not disputed. Subsequently, the taking person,
It appears that the very identity of the land is in question. Annexure C, can you please show us? Annexure C is the earlier sale. Correct?
Father gate. The property on 27 by 1946. complaint father, they will not make. That is the your father, there is no one. Whoever police are, alliance, that is the present complaint father. During the lifetime of father, they never question the legality of the father, father. Living the argument saying that the life date is 98. Right to that one, there are the other two are 54 transactions. That is the ultimately significant the father itself has told to somebody and he tells and then against that.
Your contentions that you were not put on notice in the first, in the proceedings by the Tahsildar and the Assistant Commissioner? You were not on notice.
For the ATM not appeared and contented in that. What is the Tahsildar, contrary to the section 29 of the Karnataka Land Revenue Act. The last completely, the other single date record will come. So last completely, 29 and may be permitted to read the contents of the summons class 2 is relevant.
AC audit itself says, notice is sent to them, returned on page 140.
No, was he served with notices first?
No.
He's
I must
not
frankly
served
tell
and
you,
deleted.
but because they were not served as the AC's order. Please look at page
Oh,
one.
it says not served.
Because he says notices sent to respondents by RPAD are returned as they are not available at the given interval. That must be heard. But that's why I said, ultimately we must be fair to them also.
Even if someone shall be served by tendering or delivering a copy of the person, someone, or if he cannot go to some adult male member of the family, deciding if there is no such adult member, the service to be effective by affixing a copy of the summons to some auspicious part show where the person summoned earlier resides or last resided. Which is the learned signature refers to section 29 of class 2 and there was no other thing.
Government advocate, are the records available? What is the extent of the land in survey number 215? The question is only this, are there two extents of 2 acre 1 gunta? If not, then if this 2 acre 1 gunta, which has been granted in favor of Vattara Gudiga has been sold by him, then probably this is what he says is correct. And whatever that be, for deciding this also, should they not have been put on notice without them? If, as a matter of fact, the extent is only 2 acre 1 gunta, then we are talking about the same property. Then the question has to be decided, then there is no question of any title dispute. If it is only one property, then there is no question of title dispute, it can go back.
Yes, finished it. Please come to page 107. What was granted to me was after. Please come to page 107. In 1946, he purchased, Vattara purchased particular land from lot 107. 1946.
27/5/1946.
Lord, please come to the English translation on the next page. Absolute sale deed on the 7th day of May, 1946, executed by Munisamiga Vattara Gudiga in favor of Lord the gentleman Lord. He purchased it from Lord.
Purchases it from Shanbo.
No, yes.
Yes.
Vattara Muniappa, not from the Shanbo.
Not from the Shanbo.
Please come to Lord.
Munisamiga
Absolute sale deed.
Vattara Gudiga, executed by Kottalu Muniappa.
He purchased in 1946. Thereafter, that gentleman, I sold my lord that to my lord to one Reddy.
Obbala Reddy.
Yes,
Yes.
that is, my lord, this land.
Huh.
My grant, if your lordship sees, please come to my lord page 309. Grant certificate, 10/12/1980.
Is later.
Yes. Therefore, that land is different, this land is different.
No, then that question will be settled if there are two lands in the same survey number. It's only if there are two lands in the same survey number. That those
But the
questions.
only thing is, my lord, what I,
Suppose there is only one land.
only thing is, my submission to your lordship is, this sale, which my lord Vadarabadaga has made, his grant itself is much later. In 1980.
Okay.
That's why, my lord, I want
No,
to.
it is not in 80.
Yes, my lord.
It is in
Please.
65. Just a moment.
65, my lord, was, 65 was, my lord, cancellation, and my lord, it was just informed that, you will be given. Grant certificate is only, my lord, in 309. Please come to page 309. At, my lord, page 318, 318. Please come to, my lord, page 321. 10th day of December 1980.
That is Kharab which is being granted. Government land which is being granted.
No, no. Utkara is, my lord,
Government land.
government land.
Yes, government land which is being granted.
Correct, correct.
Can only be that way.
Yes, absolutely. And 183 also, my lord. My lords may be pleased to see.
Land should not be alienated for a period of 15 years.
Correct.
This is in, according to you, when is this?
Official memorandum, my lord, in my
10th day of December 19.
73. Therefore, 67 is.
I think page number 183.
And then, secondly, my lord, the conversion order is of no relevance now because 2008, my name was there. Then a single judge says, cancel it and then put his name. Now, therefore, my lord, he says 2024, my name has come. That, my lord, is because of the order passed by the Leonard single judge. One. Secondly, he also admits, interim order passed by this honorable court, my lord, when he filed it, I was asked not to cut the trees. That means I am in possession.
Both you are that's why I find it from the beginning of the both the parts of the part of the
Appellant and respondent number 4, including 1 to 3, shall not take any precipitative action to cut and remove trees. Yes. Yes.
By all of us together.
Probably we can find out just how much land there is in the. That is all. Please get instructions on this. So how much of land there is. If they are separate properties, then probably this may not affect anybody. Yes, government is requested to get instructions. To the extent. The land. It's a number 215 of Successor, which I noted. I got the situation right. 40. Take some time. It's liberty.
Second, third, yaad. Huh? Second.